Thank you all for being here this afternoon. Actually turned out to be a kind of nice day here for those of you in Washington. So this is a two-panel discussion today because there's so much to talk about in this area. So we started a project around Section 230 a couple years ago, just kind of seeing that the intersection of technology tools and information flow were heading into probably into the courts, and we were right. And then we had the good fortune of having Clay be a colleague of one of our colleagues, Dr. Mark Jameson, who has worked with us for quite a while at the University of Florida. And Mark said, I think Clay would like to kind of join the team. And it has been so much fun to work with Clay because every day when the Supreme Court might do something is like Christmas for him. It was so much fun to get, you'd wake up and I was like, I don't even have to look at the news. Clay's already sent me an email that's going to tell me all the things that I need to know. So the first panel is going to discuss the two cases, plus probably last year's cases that came out in the Supreme Court and the opportunities and challenges that provides in the legal system. And then my panel afterwards is going to do what I'm calling the "What about me?" What does this mean for all of those people that love the internet, use the internet, use as a business, as an individual consumer, and we will have a lot to discuss along the way. We will have Q&A for those of you in the room. We'll have a mic runner for, hey, Kate, real quick, if they want to send something to, on the X. On the X, you can send questions to @AskAEI Tech. So we will be fielding those. So I am going to turn it over to Clay.
Well, thank you very much. Three big Supreme Court cases that were decided this year, and those cases involve the First Amendment and social media platforms. So along the way, we're also going to discuss some problems the justices had with squarely resolving two of those cases, declining to rule on their merits, but nonetheless issuing some important statements along the way. So first, let me introduce our panelists, and they are direct from Atlanta Airport, where she spent the night last night. That's the truth. Thank you, Delta. Larissa Lindke, the Raymond and Miriam Ehrlich Chair in U.S. Constitutional Law at the University of Florida's Levin College of Law. Her research focuses on the intersection of the First Amendment and tort law, with an emphasis on free speech and new technologies. Professor Lindke is co-reporter for the third Restatement of Defamation and Privacy and is the new author of Sack on Defamation, a leading treatise on all things libel and slander. And to her right is Jeff Hermes, who has served for 10 years as Deputy Director of the Media Law Resource Center, a membership organization for media and First Amendment attorneys. At the MLRC, Jeff studies developments and trends in digital media law. He previously served as director of the Digital Media Law Project at Harvard University's Berkman Center for Internet and Society, where he led initiatives to study and answer to the legal needs of independent journalists and online media ventures. And last but not least, all the way down on my right is Daniel Lyons. He's a non-resident senior fellow and my colleague here at AEI, where he focuses on telecommunications and internet regulations. He's also the Associate Dean of Academic Affairs and a Professor of Law at Boston College Law School, where he teaches courses on telecommunications, administrative, and cyber law. Before entering academia, Lyons was a practicing attorney with firms such as Gibson, Dunn, and Crutcher. So with that, let's move on to the cases and how we're going to proceed today during the panel. First, we're going to go one case at a time, but making connections along the way and touching on larger questions as they do arise. Second, I'll briefly describe each case, about 5 to 6 minute setup before turning to the panelists. And then third, we'll leave about 15 minutes at the end for your questions and those who are watching out in, as I like to say still, the cyberspace. So let's start with the first ruling the court made this spring in Lindke versus Freed. So unlike the other two cases, Lindke involved a unanimous ruling and a single opinion, one by Justice Barrett, who would also write the court's opinion in the second case we'll be discussing today, Murthy versus Missouri. So by way of background for Lindke, recall that when Donald Trump was president, he got into First Amendment trouble for blocking people from his personal @Real Donald Trump Twitter account. The people he blocked were ones who had criticized him. So because Trump used his personal account for all manners of official public actions, including firing people, the lower courts had little problem finding that his use of it triggered First Amendment problems when he blocked people based upon their viewpoint. Conversely, no First Amendment problems arise when a public official uses a social media account in a purely private way, say bragging about a daughter's accomplishments, posting family recipes, or posting vacation photos. In such cases, there's no state action that would allow a blocked citizen to assert a First Amendment claim. It's only private action. But sometimes it's not easy to tell, particularly when an official uses an ostensibly private account in a hybrid manner, mingling vacation photos with job-related posts. And even when public officials do mention job-related business, they may be posting about it in their private citizen capacity. They aren't always on the job, they aren't always on duty, and they do have First Amendment rights of their own. So in Lindke, the court created a two-part test or a rule for deciding when a public official's, and I quote, posts about job-related topics on social media, unquote, are attributable to the government. When do they, in other words, constitute state action? Justice Barrett wrote that, quote, such speech is attributable to the state only if two conditions are met. One, that the official possessed actual authority to speak on the state's behalf, actual authority, and two, purported to exercise that authority when he spoke on social media. To meet the first part, the actual authority part, Barrett explained that a plaintiff, a blocked citizen, must prove that the official's post was connected to speech on a matter within the official's bailiwick, that's her term, or fell within his portfolio, also her term, of official duties. So actual authority may be created either explicitly by a statute or by a long custom and practice of the person exercising that authority. If a citizen's post is about such bailiwick or portfolio matters, and that's what caused the person to be blocked, then the first part of the test is satisfied. Under the second part, whether the official purported to exercise his authority when he posted, Barrett said a court should examine the appearance, content, and function of the account. Context is important here for this fact-specific undertaking, she wrote. Justice Barrett noted that an official who includes a disclaimer declaring it a personal page is entitled to a heavy, though not irrebuttable, presumption that all of the posts on his page were personal. Conversely, an official who uses government staff to make a post will be hard-pressed to deny that he was conducting government business. That's what Barrett wrote. And that's all that the court did in Lindke. It created a rule. It didn't apply the rule. It's now left to lower courts to apply that two-part test. So my questions for our panelists, and we'll just go down the line, and feel free to interrupt or chime in. Not interrupt rudely, of course, but if you want to say something somebody said, please do so. So my question is whether you like the rule or not, and why or why not, and additionally, what are its practical implications for how public officials might use social media accounts going forward. So Larissa?
I'm a little disappointed because I think the default tilts, if the government official pays attention at all, the default tilts against these sites being treated as public forums. I've previously written that if it looks like a duck and quacks like a duck, it should be treated like a duck. It should be treated like a public forum. But the public forum doctrine, of which this is a kind of precursor part, says that government intent to create limited forums is the most important thing. So if you're just smart enough, if you get the right advice and you're smart enough, you can make sure you can dismiss your critics with impunity fairly easily. And to me, I think that's unfortunate. I think our government officials should have to, take a little criticism here and there and have thick skins and go on with their lives.
So it makes it too easy, essentially, to declare it a private account.
Yeah, that said, I thought the facts here were really, this was a bad case to take up because this guy, it really did look very private. Okay. Very much like a private account.
Jeff?
I also was disappointed with the decision for a few reasons. The first being, as you mentioned, the court did not actually practically apply the standards which it enunciated. And I think it's actually very difficult to figure out from the text of this opinion how to apply those standards. Indeed, there were what might be considered internal inconsistencies even within the court's discussion. The court at one point says, well, generally websites won't be all public or all private. They could be some or either. But then at another point says, but if a public official posts an ambiguous post on a private page, that should be considered private, except we've just talked about the fact that it's not always clear what's public and what's private, and characterizing a page as private is problematic. So eventually, the court left it to the lower court to figure out whether it had complied with this standard, and so it's not even so clear as to whether this is even an affirmance or a reversal in practical effect. But getting away from that, there are some other very interesting pieces in here, and one I just wanted to call out, which I mentioned to you earlier. As you mentioned, President Trump ran into this issue in a case which the court wound up not deciding earlier, in a case brought by the Knight First Amendment Institute at Columbia. And the court seemed interested in addressing that situation in the text of this order. And this is something I think will come up in a number of the cases we're talking about today, the court addressing other cases through these decisions. And what was interesting here was that you have the court saying, one thing we'd like to note is that, as you said, a public official can address public issues in a private capacity, and that won't trigger the First Amendment scrutiny. And one of those capacities that the court mentions is a candidate running for public office. And that so you can have a situation in which a candidate running for public office, even though a public official, will still be treated as a private individual. Which raises a very interesting question with respect to another decision that the Supreme Court issued this term in U.S. versus Trump on immunity for presidential actions. I expect we will see this decision come back in later arguments about whether, for example, statements that President Trump made on January 6th should be considered within his power and thus within the exercise of executive authority, and thus, he should have immunity for those statements. Or is this a private statement, and so he shouldn't? I don't think the Supreme Court was necessarily thinking about that question when they issued Lindke, but I do think the language is interesting enough that we could see that coming back in other contexts.
Daniel?
So I remember when we were kicking around the first iteration of this fact pattern, the Trump v. Knight Institute case, and Jack Balkin gave a talk on it and basically said, the public forum is a public forum if the government official decides it's a public forum, or otherwise it's not. Right? And that's about all the tests we have. So in that sense, Lindke kind of helps advance the ball maybe a half step beyond that. It's at least purporting to create some a two-part test as opposed to kind of the mishmash that we had before. I was also disappointed it didn't then apply that test to these facts. I agree with you that I think the Trump v. Knight fact pattern was casting a long shadow in the minds of the justices as they were deciding the case. It's a much more obvious issue, a much more obvious application of that principle than the facts upon which this case arose. One thing I thought was really interesting was it was almost like a Parthian shot at the end. Justice Barrett says, one ramification of this decision is it may matter what remedy the government official is taking. There's a big difference between deleting a comment and blocking a user, right? Because if a particular Facebook account or whatever can be public with regard to some comments and private with regard to others, then the decision to block a user may be okay at time A when you initially block him for responding to a private speech, right? But leaving that person blocked so they can't comment on a public comment later, public message later, could become problematic over time. I think that's super interesting.
Oh, and if I remember correctly, there was also the issue about whether or not you were being blocked from the account entirely, or whether just your post was being deleted. And so, and I think that's a really interesting thing to raise, because that idea of how the tech functions mattering will come up again and again today, right? Mm-hmm. I mean, it's certainly going to come up when we talk about NetChoice.
Yep, exactly. Larissa, do you want to follow up on anything?
Well, I do want to follow up that there's a common thread running through a lot of these cases this term, in that the court is critical at points of how you chose to litigate your own case, and if you chose to, for example, to bring a facial challenge versus an as applied, or if it was, what procedural posture or what remedy, First Amendment remedy you sought. And I think it's going to force us in the future to pay a lot more attention to those issues.
About how we litigate the cases.
How we litigate the cases and what we ask the remedy to be.
Okay. And do you think that Justice Barrett gave basically this roadmap at the end by saying, well, if you put a disclaimer on your page, there's a presumption, it's not irrebuttable, but it's a large presumption, a strong presumption in your favor. So why wouldn't every politician or government official now just have disclaimer, personal page on their site? And then she also says, well, if you use government staff to do the posting for you, or they monitor the posts, then
it goes the other way. So what happens when you have a public official who puts the label on the page and then has their staffers posting to it? I mean, there's no answer to that, right?
Right. So the lower courts are basically going to have to figure this out over time. So when you started, Larissa, it's really we're balancing the interests here, right? We're essentially saying is how easy do we want to make it for a citizen to be able to sue a public official who, as you just pointed out, Jeff, either deletes or blocks, and we don't know. And so the functionality part is interesting too, and we're going to see that especially, I think, when we get to the Moody case in NetChoice, because the court was really concerned about all the different functionalities. And so if it's a sweeping, I simply block you from my X account, that's one thing. But if I simply deleted a post, and then we've got to figure out, because remember, is that post what caused the person to be blocked? And that seems pretty difficult to go back into it. Any thoughts before we move on?
Well, except that if you're talking about a broader block, I think the court's pretty clear that it doesn't matter what led to it.
Right.
If there are, you have to look at everything that person is then blocked from. So you can have the tail wagging the dog, as it were,
Right.
in that circumstance.
Yeah, so preventing the constituent from speaking when you're speaking on a matter of public concern.
I just think at a time, and the court acknowledges this in some of the other cases, at a time when the government uses social media as such an important tool of governing, but also as a sphere of public discourse for citizens to interact with their government officials, I would put my thumb on the scale of speech interest rather than the interest of the official to not tolerate viewpoints that they don't like. But I feel like they tilted the scale slightly the other way.
The opposite direction.
Yeah, that balancing of interests also comes up a lot in these cases, and thank you, that's an excellent.
And just kind of close the circle on this part, we're talking about the public forums. What the court in the Second Circuit had said in the Trump case, the night one, is that the interactive portion of a social media account, the interactive part where I can reply and like something or retweet it or, repost it now, that type of thing, that's what we're talking about, the public forum part. And so that's where we're saying in that space. And again, the functionalities we're going to get to in the NetChoice case will be really important to talk about. Are we good? All right. All right. So let's move on then to our second. We promised that would be the shortest case that we had. So it was just simply the rule, right? So let's move on then to our second social media case, Murthy versus Missouri. So this is the verbal arm twisting or jawboning case, centering on just how much written and spoken pressure the government can lawfully apply to third-party speech intermediaries. And here the intermediaries are social media platforms, to try to get them to remove or deprioritize the speech of others who post on them. So the question really is this: when can the removal or deprioritization of others' posts by the platforms be attributed back to the government such that it amounts to government censorship violating the First Amendment? If the platform's censorship decisions are made independently, are their own, then there's no First Amendment issue. So in Murthy, Missouri, Louisiana, and 5 individuals, including 2 authors of the Great Barrington Declaration, a document questioning the Biden administration's COVID-19 policies, sued Biden, White House officials, the Surgeon General, the CDC, and multiple other government agencies and officials, claiming they all had unlawfully coerced or significantly encouraged the platforms to remove, demote, or place warnings on conservative tilting content regarding the 2020 presidential election and the pandemic. Murthy thus is about what we would call informal censorship rather than making a formal law, and making distinctions between permissible persuasion and argumentation on the one hand, permissible persuasion, and unlawful coercion, including explicit or implicit threats of adverse consequences if action isn't taken in accord with the government's wishes, on the other hand. In another case decided this term before Murthy, called National Rifle Association versus Vulo, a unanimous court was clear, and I quote from Justice Sotomayor's opinion for the court, that, quote, government officials cannot attempt to coerce private parties in order to punish or suppress views that the government disfavors. That would amount to unconstitutional viewpoint-based discrimination against speech and the speaker. The court in Vulo reaffirmed a 1963 decision called Bantam Books versus Sullivan. A Rhode Island commission there had unlawfully coerced book distributors, so the book distributors there are the speech intermediaries, to stop distributing books published by Bantam Books and others that were allegedly indecent for minors. So really, who's getting squeezed, right? The speech intermediaries being squeezed by the government. The court held that, quote, informal censorship, unquote, may violate the First Amendment. The justices were explicit that public officers thinly veiled threats to institute criminal proceedings against the book distributors, they would be prosecuted for obscenity, were unlawful. The court in Bantam Books held that a government entity's, quote, threat of invoking legal sanctions or other means of coercion against a third party to achieve the suppression of disfavored speech violates the First Amendment. So in Murthy, both a federal trial court and the Fifth Circuit Court of Appeals ruled for the plaintiffs and against the government. The Fifth Circuit last October issued an injunction barring the defendants, again, Biden and all the government officials and agencies, from coercing or significantly encouraging a platform's content moderation decisions. The Fifth Circuit added that, and I quote, social media platforms' content moderation decisions must be theirs and theirs alone. The Supreme Court, however, in a 6-3 opinion written by Justice Barrett, held that Missouri, Louisiana, and the 5 individual plaintiffs all lacked standing to challenge the government's actions. Without standing, the Supreme Court lacked authority to hear the case. The government won and the plaintiffs lost. The majority essentially punted on the merits. Now, standing, and we're not going to go too deep into the weeds here, but it is important to understand what it takes a little bit. Standing requires proof of an injury, that the injury was traceable or caused by the defendant, and 3, that the relief sought by the plaintiffs in Murthy, that would be an injunction barring the government officials from doing this in the future, would redress the injury. So injury, traceability, and redressability are the 3 basic elements. The majority was comprised of 3 conservative justices, Barrett, Roberts, and Kavanaugh, and 3 liberal justices, Sotomayor, Kagan, and Jackson. The dissent was comprised of the court's most conservative justices, at least as we stereotype them, namely Alito, Thomas, and Gorsuch. They found that one plaintiff, a Louisiana, dissent, they found that one plaintiff, a Louisiana activist named Jill Hines, had standing, and that's all you need is one of those plaintiffs to have standing to go and challenge it. And they reached the merits in turn, ruling against the government. So they went off and said, okay, we're not only going to say she's got standing, we're going to reach the merits of the case and find that unlawful coercion existed. Alito wrote for the trio that, quote, for months, high-ranking government officials placed unrelenting pressure on Facebook to suppress Americans' free speech. Because the court unjustifiably refuses to address this serious threat to the First Amendment, I respectfully dissent. And so with that background, let's go to our panel. I'm just going to keep going down the same order, especially since you had to spend the night in the airport. and nobody else did. You flew in this morning. You cheated. Anyway, so Larissa, so although the court dismissed Murthy on standing grounds, the issue of censorship by proxy, or informal censorship, is real and serious. And there is evidence that the government has influenced platforms to take down information that later turned out to be true. Now, that should alarm all of us. The court seemed to recognize the danger of government censorship by proxy this term in Vullo, the one I mentioned earlier, the NRA case, when ruling in favor of the NRA by letting its case go forward against a New York official, Maria Vullo, who tried to convince major insurance companies not to create insurance packages for NRA members. So my question for you, and it's a big picture question, is just how concerned should we all be about censorship by proxy when it comes to government pressure on social media platforms, given that the majority dodged that issue? And then secondly, what can or should be done about it, either by the courts or the public or by lawmakers? And anybody can chime in, too, on this one, too. But let's just start.
Okay. So I think we should be very, very concerned about this, because you had evidence on the record here that this started in the Trump administration. The Twitter files revelations are at the back of this case. And it started in the Trump administration, including during the pandemic, and then carried forward into the Biden administration, that they leaned on the platforms to shape the shape of public discourse about things like pandemic response, things like election misinformation and disinformation. And while you might think some coordination to solve some of these problems would be good, the government officials here were really heavy-handed. There were individual pieces where, especially some of the folks from the White House would get really, really angry at the platforms for not moving fast enough to take things down that they thought inspired vaccine hesitancy. The Hunter Biden laptop theory was one of the things that they were pressuring them to take down because it was a Russian hack, supposedly. We now know that that wasn't true. The lab leak theory was one of the conspiracy theories that we now know is one of the dominant theses. It was called a conspiracy theory then. Now it's one of the dominant theses. And to me, what this illustrates is We should always distrust the government when it has power over a choke point for public information, because for two reasons. We distrust the government because fear of tyranny, because the inevitable push to shape public information to stay in power is always going to be there. But here, this illustrates fallibility. They'll just get it wrong. They'll say, this is authoritatively the truth. We can't have anything else out there in the public sphere. And it turns out they'll be wrong. And this case illustrates that. Unfortunately, the people behind the litigation didn't match up the pieces to show the causation between the government leaning heavily and being coercive towards the platforms and the individual speakers ending up getting censored by the platforms, that maybe they were doing it pursuant to their own policies and not under government influence, and therefore an injunction against the government wasn't warranted.
And that's what affected the standing part, right? Because
Yeah.
they couldn't show this traceability, that there may have been independent decisions, I believe,
Yeah.
and also the temporal sequence. In other words, some of the censorship had gone on before the government started leveraging the social media platforms. So just, it was very difficult to do.
Well, and then, I'm sorry, and then
No.
an injunction says you're going to censor me in the future. So the remedy chosen in this case is different than in the gun case, the NRA case, Polo, because they're asking, the theory of their case is you're going to keep censoring me in the future when the government leans on you. And they said, yeah, there's no real evidence of that.
So let me go to the back half of that question quickly, is who should take action, Larissa? Is this something the courts need to readdress? Clearly, I think we're going to have a case like this. Again, I don't think this is the last case we're going to see like that. You want to go, or Jeff, you want to chime in?
Sure. I mean, I think there are a couple of things which are going on here. I'd just like to echo what Larissa said with respect to the kind of pressure which government agents were putting on tech representatives. My organization includes many tech companies as members alongside our other media member organizations. And I've spoken to attorneys, people who are not easily rattled, talking about how uncomfortable it was to have these conversations with members of the Biden administration and telling me that they really felt severely pressured to make these decisions. So I think I just want to voice that as support for the point you're making. I mean, part of what's going on here is that, again, and this is something we'll see in some of these other cases, is that you're seeing the states in this case and the other groups who join them as plaintiffs seeing a big sweeping speech problem in the country. And they're attempting a big sweeping solution to that problem. And it feels like we need a big sweeping solution to this problem because you've got a systemic issue. But then you run into the problem of whether or not the courts are actually designed to handle those questions. And here, you know, the court was saying, no, we're here to handle cases and controversies, specific issues. You need the person who is affected by this decision to be the one who comes to court seeking the resolution. And you need to draw a line from the government action through the removal to the person affected before you get to that point. And to a certain extent, sure, you know, a conservative view of the role of the courts supports that decision. It does feel like we need some other kind of mechanism, though, to deal with these structural issues. I also want to point out there's something of a paradox built into some of these cases. It sounds like, you know, if your speech is removed from Facebook because a government official has put pressure on Facebook to remove your speech, that what you should be able to do is go into court and say, Facebook wasn't operating under its own power, it was acting as a branch of the government when it did this. I want an order telling Facebook to restore my speech. But that creates a problem too, because then you get another branch of the government, the court, ordering Facebook to do something that it might or might not have done on its own. And so we're back to square one in some sense. You know, at least one court which has looked at this issue, Federal Court of Appeal, has said that the answer is just to declare that this was unconstitutional, tell the intermediary you won't get in trouble for your decision. Whether they believe that or not is another question, very tricky. And then say, okay, you're free to do whatever you want. Go forth and make the decision again. Go ahead.
I was going to say what you've just described in part is a separation of powers issue that's partly complicated by the growth in power of the executive branch. And especially during the pandemic, there were really some arrogant statements by certain of those government officials. I encourage you to go read it. It's very, very interesting behind the scenes glimpse into what's going on. What disturbs me too during the oral arguments, Justice Roberts and Kavanaugh were like, well, the government calls up the media and pressures them to kill stories all the time, maybe national security, maybe this, maybe that. Here's the difference to me. One is any one media organization doesn't control as wide a swath of information as Facebook, but the media has an interest in publishing.
Right.
That's their job, that's their mission, it's not Facebook's mission in the same exact way. Any one piece of information is less important than maintaining their legislative immunity under, Section 230 of the Communications Decency Act, which was one of the things implicitly threatened that they might lose that.
Yeah, that's really problematic.
Ironic that Section 230 is actually the law which is supposed to deal with that imbalance in terms of interest and whether you're the publisher or the intermediary, right?
So when we're speaking about threats of adverse consequences, one of the things, what would be coercion? Section 230 was the thing that was raised in the balance. The notion that somehow Section 230 will be revoked or removed unless you do this was kind of the subtext. Daniel?
Yeah, no, I think that's right. I think at the 10,000-foot level, right? I'm always uncomfortable when the government is trying to tilt the marketplace of ideas. And there's a sense in which, like, this case and the one we're going to talk about next, NetChoice, are two sides of the same coin. One is the government removing information from the marketplace, and the other the government trying to put more information in the marketplace, right? But I think disinformation concerns is the more significant problem of the two. And I never miss a chance to plug Thomas Kuhn's structure of scientific revolutions, right? How do we learn? He uses the example of Copernicus realizing that the sun doesn't go around the earth, the earth goes around the sun, right? You have a dominant paradigm and everybody believes it. And then eventually over time you learn the dominant paradigm isn't as dominant as you thought it was, right? And eventually some quack comes along and offers an alternative explanation. And allowing that to sort of compete in the marketplace, you eventually realize maybe the truth isn't A, maybe the truth is B, and eventually the scientific consensus shifts, right? Copernicus noticed there's a problem with the Ptolemaic system. The heavens don't behave the way that a geocentric model would. And his original heliocentric model was equally problematic, but gave a place for that alternative viewpoint to coalesce. And eventually that overtook it. You have a problem when the government, in that case it was the Catholic Church, steps in and prevents that learning process from going on by calling that minority opinion disinformation.
And that was really the way this case was framed, and I've written about this a little bit, was like, it's such a politically fraught case. From the liberal side, it was framed as this is a battle about our ability to remove disinformation that is going to harm people and harm their lives. The pandemic is going on. We have to be able to do this. From the conservative side, it was really just the opposite, right? We're trying to express viewpoints that you want to quash government just because they're dissenting viewpoints. And to go back to what you just said, they might actually be correct and lead us to another path. And as Larissa said, some of them turned out to be correct or now have changed in terms of how they're framed. So other thoughts before we move on to the question for Jeff? Daniel, anything else? Larissa?
I think I've said it.
Actually, one more thing.
Yeah.
One thing about this case that makes it distinguishable from Volo, and the court says this, they said discovery has already happened in this case. We've already gotten the documents so that the parties could have proved the causation of they were censored because of the government speech, and they just didn't connect the dots. There's really an implicit criticism of the parties here. And the other thing that goes on in this case that we're going to see again in the other cases is a criticism of the Fifth Circuit, the U.S. Court of Appeals for the Fifth Circuit, which is, includes Texas, Louisiana, that segment of the country, that they're the most overturned set of the Court of Appeals now, and they're starting to be perceived a little bit as like a rogue circuit out there doing lots of things that need to get reversed. And I appreciate it because I clerked in California on the Ninth Circuit, and back in the day, they were the rogue circuit back when I clerked there. So I'm glad somebody else has taken on the mantle of being the rogue circuit.
I was about to make the same joke.
One thing we might think about whether this case was simply, I think Barrett used the term sprawling, it was too large, too broad, and whether a more crisply focused on one or two particular plaintiffs rather than what amounts to almost a giant class action in some way, right?
But that raises the question we were kicking around earlier before the panel started, right, about performative litigation, right? What a more narrowly focused claim may not have grabbed the same headline. So it's unclear for what the plaintiffs were going for here. They may have gotten exactly what they wanted, which is a lot of press coverage about the fact that this government interference was happening. Maybe it was a win by a loss.
Yeah, and actually, case in point, there have been any number of these kinds of cases filed by individual plaintiffs in the Northern District of California, which get a lot of coverage in the tech law press, that tiny, tiny segment of the reading public, but I don't think any of them have really made national headlines.
That's interesting. I did not realize that. So dozens going on up there?
Oh, yes.
Okay, okay.
And most of them just broomed very quickly on the theory that there hasn't been sufficient coercion to constitute state action.
Okay. And so we're left with this test from Bantam Books, which is not very clear, but we do have some test reaffirmed in Vullo and then not applied, basically. And so again, the court never really applies anything. Remember, Lindke creates a rule, doesn't apply it. Here, we don't even apply it from Vullo. So
Vullo at least gives some coverage, right? I think Vullo allows the court to do what it does in Murthy.
it does.
By saying, no, but Bantam Books is still good, we're just not applying it. This isn't the right case for that.
Right, and in fact, the Vullo court went a little bit further and said, not only, it made it even vaguer. They said the courts of appeals have established, as courts of appeals love to do, these multi-factor tests to try to figure out whether or not there's been unconstitutional coercion. Those can all be misleading. It's really this sort of holistic view about what went on in the situation, which drives litigators absolutely insane.
Crazy. All right, so Jeff, this one's for you. So the resort to standing in Murthy seemingly relates to the court's struggles this year in resolving larger structural First Amendment questions.
Yeah.
It also taps into the Moody NetChoice case we'll cover next, where Justice Thomas suggested that facial challenges like those raised by NetChoice are verboten under Article 3, and the court shouldn't simply hear them, as well as to cases like Vidal versus Elster. This is the Trump too small trademark case, where the court was incapable of reaching a consensus about exactly why the names clause of the Lanham Act. And what the names clause does is it bans the use of a living person's name in a trademark without their consent. Why that was consistent with the First Amendment. There was disagreement, history, whatever. They can't agree. So can you talk a little bit about some of the problems the court seemingly has in resolving the structural First Amendment questions, and whether it's perhaps using problems with standing, as we saw in Murthy, in facial challenges later in NetChoice, to dodge First Amendment questions?
Sure. I mean, I think it's easier for the court to resolve a First Amendment question when it's narrow and confined to its facts. And as I mentioned earlier, one of the things we're seeing is these big sweeping kinds of cases posing big sweeping problems. And that's true of the NetChoice case, which we'll get to in a moment, where you have states passing big sweeping laws on content moderation to respond to what they see as a big sweeping problem on social media, leading to a big sweeping lawsuit in response. The Vidal versus Elster case you raise, it's interesting. Of all the cases the court decided this term, this is the one that drives me the most crazy. And not because it's necessarily posing the most important problems, but because it evinces a serious lack, in my opinion, of a central theory of the First Amendment on the court. Mm-hmm. The question seems very straightforward. The Trademark Office has a rule which says that if you're going to try to register a trademark including a real person's name, you need that person's permission. Okay, is that constitutional? The court says, well, that's a restriction which focuses on the content of the speech. Ordinarily, that would cause courts to give that provision strict scrutiny, but that doesn't feel right here. And the entire court said, there was a unanimous holding, this does not violate the First Amendment. But there was no consensus whatsoever about why. Justice Thomas writes a long opinion saying, well, it's always been this way and it seems to work, good enough for now. Justices Chief Justice Roberts and Justice Kavanaugh join that opinion, but there's a two-paragraph concurrence saying, but we don't think you even really need the historical stuff, we just don't think there's a problem. No real explanation why. Justice Barrett goes off in another direction, analogizing this situation to public forum law. And then you get Justice Sotomayor, I believe, going off in a different direction, talking about the unconstitutional conditions doctrine. None of these, I won't go into any detail about what all of these doctrines are, but the point is that you've got these justices looking at a First Amendment question and having no idea which rubric under which to solve it. No 5 justices agreed on this point. And that raises serious concerns for me. because it raises concerns if you don't have a central theory of the First Amendment. Not only do you run into questions when you have, about provisions which have long existed but you haven't really thought about, but you have no basis to go forward and start thinking about tough questions involving new technologies, new media, new communication. And in those circumstances, I worry that the court feels pressure to find other ways out.
Larissa, do you want to?
I do, but I wanted to give you a chance first.
Yes, sorry.
I was going to say, I think I'll hold most of what I'm going to say because I think it's also applicable to the NetChoice cases where I think this exact same dynamic comes up.
This is kind of a side issue, but so it's well known that the Supreme Court is taking fewer and fewer merits cases each year, a little over 50, down tremendously from where they used to be. And as a result, they write these sprawling, there's the word, sprawling opinions, and even when they're unanimous, each one has to have their own word because they have to speak to their band of law professors. And it really, in my mind, and this case illustrates it very well, is the case partly shows that there's not as much respect for just pure precedent as previously. Thomas is floating out that history approach to solving First Amendment issues like he's used in Second Amendment cases. And B, it's just disrespectful for how litigation works and how real lawyers advise real clients about their problems. And to me, it's becoming a problem it's almost of a rule of law threatening nature that the justices aren't writing for clarity for litigants and clients. But anyway, but you see that in a lot of these cases, they're not as divided as you might think mostly, and yet the plethora of opinions creates real problems about how to advise a client going forward.
Yeah.
Which, whether they intended to or not, winds up being an invitation to the Fifth Circuit to go their own way and ignore precedent time and again.
Yeah. And Jeff's point about theory is right on, because basically the theory should really drive the doctrine. If you had a central theory that you all agreed, here's the theory why, then you would say, like, content discrimination against speech is bad because it skews the marketplace of ideas. There's our theory. Then you say, okay, the doctrine is we're going to apply this really difficult, you mentioned it, strict scrutiny standard to content-based regulations. But now, like in this First Amendment toolkit, there's so many different ways to go, and they cannot agree on it. And so, as Larissa said in the Bruin case, the Second Amendment case, a couple of years ago now, Justice Thomas and the court clearly endorsed this text, history, and tradition approach to analyzing cases. And so there's been this theory, or not theory, I shouldn't say that, but some concern or worries among some quarters that text, history, and tradition would now migrate into First Amendment law and supplant what we were typically thinking, is the law content-based or content-neutral? If it's content-based, you apply strict scrutiny. If it's content-neutral, you apply intermediate. And then that goes to the Vidal versus Elster, because that's where Coney Barrett comes back and really says to Thomas, you're wrong 2 times over, or something like that. She had something, right?
Yeah.
So that's where we are. Daniel, let me go to you on this. Sure. So the court in Murthy declared that both the state plaintiffs and the individual plaintiffs lack standing to sue. And again, remember, that was the injury, traceability, and redressability, 3 parts. So my question for you is, what will it take for a state now in the future to demonstrate that it has standing in a future jawboning case against the federal government? Such a case seems inevitable. Just how difficult will it be?
Yeah, I think it's a good question, and this gets back, I think, to the performative litigation point we were talking about earlier, right? Because one of the reasons why states get involved is when a state is a plaintiff, it draws a lot of attention. And a lot of the states that are getting involved in these situations are doing so for largely political reasons. And the court's been open to that for the past decade and a half, right? So Mass v. EPA, the court explains that states are special. There's been some dispute, special good, special bad, right? Does this mean that we're easing the theories that a state can bring theories that a private plaintiff can't? Does it mean it's harder for the states to bring theories that a private plaintiff could bring? This is one of the cases that seems to be falling in the latter category, right? So the state's 2 theories of standing here were, 1, you blocked some speech by a state representative. And the court said, well, this has the same problem as the individual plaintiffs, that you didn't say which statements at which times or connect it back to government pressure. But then they explicitly say, and so we're not going to opine on whether, if you had crossed your T's and dotted your I's, that blocking the speech of a state rep would be sufficient to give a state standing. So it invites the question, why isn't the state rep the one bringing the case, right? The other theory, and this was in the line of states continuing to stretch the outer boundaries on what it means to have special rules, right, is the state had asserted a right to listen, right? That anytime you're blocking anybody on Facebook, you're preventing the state from listening to its constituents. And the court was like, whoa, wait a minute. A, you again didn't prove that one. B, that's a bad theory. that gets in the way. There are rules about not bringing claims on behalf of somebody else, and this gets awfully close to that, right? There are some instances in which a state can act, what's the phrase, like in parents patriae? Right. This was not that. It gets too close to our traditional rules. So it's pretty clear that if a state's going to be a plaintiff going forward, their best bet is to have alleged direct harm, right? In the Medicaid circumstance, it's like this Medicaid rule is going to limit the amount of funds flowing to us as the state. It's unclear that how much the state can act as a proxy for citizens or even a proxy for one of its employees.
I'm sorry, but yet it feels like there should be some way to do that, right? Because otherwise the reason I mentioned all of these California cases which have been being kicked out, the reason why those fall apart most of the time is because individuals who suffer the effects of government pressure often have a very difficult time proving it. They're not in a position where they know what happened, right? So they're often fighting blind. They're saying, well, I wrote on this topic. I know this topic is disfavored. I know this administration has spoken on this topic. I am drawing an inference that what happened here is that there was pressure which affected my content. That inference generally doesn't do the trick in terms of your burden of proof. But if you can't bring that kind of claim, then how do you get over the fact that there are these systemic issues that are affecting these plaintiffs in order to find some remedy for what is happening?
Yeah, in a sense, it's a federalism question, right? Yeah. It's bringing the big guns of the state to back you up against a claim that the big guns of the feds are silencing you. Yeah. Of course.
So I think one of the biggest problems with these cases for me is that the federal government is trying to make censorship decisions without accountability because we don't even know it's happening. And one of the beauties of this litigation is it forced into the open that it's happening. And, a lot of people weren't outraged by that, but some people were outraged by that. But how would we regulate to enforce transparency obligations around, this kind of government policy being presented to platforms as a basis for them setting their own policies about what to take down?
Because that jawboning, as we were talking about it, that verbal arm twisting, it as you suggest, it doesn't occur in the sunshine. We don't know that it's going on. We have no idea. Versus, so informal censorship that we're just talking about, but formal censorship, if you're adopting a law, we know what's going on at least, right? There's a give and take of the legislative process. Somebody drafts it, it's going to be changed. So the fact that we're left in the dark about what's going on, I think that's a great point, that we finally were exposed by the process of discovery to some of those damning emails, really. Other points? One thing I wanted to add on this too is we're talking about the states asserting this. The state said that right to listen is their sovereign interest, right? So they're not claiming that's a First Amendment interest. They're saying this is our state's sovereign interest, our right to listen to what our citizens have, because that in turn informs our policies and our lawmaking, right, as we go through this. So the right to listen, the Supreme Court has recognized that at an individual level, a right to receive speech, a right to receive information. So the next question might be, would an individual, that's a First Amendment claim, right? I've got a First Amendment right to receive speech. Daniel, what do you think about that? Would they have better luck if the individual plaintiffs would?
So Justice Barrett talks a little bit about that, right? So the right to listen, as it's been acknowledged by the courts thus far, involves some sort of special relationship between the speaker and the listener, right? The fact that I live in the state of Missouri is probably too tenuous of a connection to fit within that that theory. So I think if we were to apply that theory and the court would uphold it, it would be one of those situations like Mass v. EPA, right, where states are special and therefore we're going to relax the traditional rules.
I'd like to just voice my frustration with the sort of derogation or pushing aside of the right to listen here, because ironically enough, the most powerful theories behind the First Amendment rely on the importance of the right to listen. The whole marketplace of ideas is about the ability to hear and receive and evaluate information. theories about, the importance of the First Amendment to democracy. It's about the ability of the electorate to receive the information they need to make decisions. And so, the fact that all of these wind up being posed from a speaker point of view as opposed to a listener point of view, and how difficult it now is becoming to bring that listener view in, I think that's a real problem.
And I think for new technologies in particular, it's such an important argument for use of tools like generative AI. The right to receive ought to be, or right to use a new technology for news gathering purposes. Even the case involving TikTok, the TikTok bans. Right. Do you have a right to use that medium to receive information that you want to receive? A more robust right in that way is going to be very important going forward for new technologies.
So just thinking the flip side, of the reciprocal side of the right to speak, the right to receive speech as we go through this. All right, and this brings us to our third and final case of the day, Murthy versus NetChoice. So this is another case where Justices Alito, Thomas, and Gorsuch distanced themselves from Roberts, Kavanaugh, and Barrett, akin to Murthy. In contrast to the Lindke case, and we just already tapped into this, Lindke, where we started today, we saw only one opinion joined by everyone. Murthy features 5 opinions, albeit no dissent, although perhaps dissent light is how some of them read. Murthy encompasses the companion case of NetChoice versus Paxton. So at stake in these cases are the First Amendment rights of platforms to decide for themselves what speech to host and how to host it, free from government interference. As Justice Kagan wrote for the court, the statutes restrict the ability of social media platforms to control whether and how third-party posts are presented to other users, thereby, quote, limiting the platform's capacity to engage in content moderation, to filter, prioritize, and label the varied messages, videos, and other content their users wish to post. A related question lurking in both cases is whether large platforms should be treated like common carriers, like a telephone or a telegraph company, businesses that simply transport messages from point A to point B and typically cannot discriminate against the messages they move. Also, you might think more UPS or FedEx. They just move your package with your letter in it. If large platforms are common carriers, then both laws are likely constitutional. Murthy from Florida and Paxton from Texas involve statutes, and I say involve because the cases are sent back down, so we're still going to hear them. Texas and Florida involve statutes adopted after the deplatforming by Twitter and Facebook of then-President Donald Trump shortly after the Capitol riot of January 6, 2021. Politicians in both states, Florida and Texas, were explicit that the statutes were intended to stop perceived liberal biases by large platforms and to level the online playing field between conservative and liberal views. So without going into too many details, our panelists can certainly raise them. The statutes collectively compel large platforms to host speech that and users who violate the platform's terms of use about acceptable speech. Texas statute bars large platforms from censoring a user or a user's expression or a user's ability to receive the expression of others based on the viewpoint expressed. Both statutes also compel the platforms to provide individualized explanations to users who've had content removed or who've been kicked off. Those explanation requirements raise First Amendment questions about compelled speech, compelling the platforms to speak, and their right not to speak. The 11th Circuit had generally ruled in favor of NetChoice when considering Florida's law, while the 5th Circuit, as we now know, often reversed, had ruled against NetChoice and in favor of Texas. So this split of authority, the disagreement between the 11th and 5th Circuits, teed up the case for Supreme Court review. But the court dodged squarely resolving the First Amendment issues. It sent them back to the lower courts to determine the statute's scopes and specifically to decide whether they apply not only, in Kagan's words, to paradigmatic social media platforms like Facebook's news feed and YouTube's homepage, those were the examples she gave, but also to direct messaging services, online marketplaces like Etsy, payment applications like Venmo, and even ride-sharing services like Uber and Lyft. Pinpointing the scope and coverage of the statutes, something the 11th and 5th Circuits failed to do, is vital because NetChoice contends the statutes are facially unconstitutional. So a facial challenge attacks a statute on its face, meaning by its terms, its language, and its text, standing alone, not as applied to a specific plaintiff in a specific factual scenario. So for the statutes to be facially unconstitutional, again by the text and terms alone, the court must first identify the full range of activities the laws cover, all of the types of platforms and all of the functionalities they regulate. And so in the Lindke, we were starting to tap into the differences in terms of blocking versus deleting, and then conclude that a substantial number of those applications are unconstitutional relative to the statute's legitimate application. So comparing a denominator, numerator, figuring out are there a substantial number of unconstitutional applications relative to the constitutional ones. So the lower courts now must do this. But there was some good news for the platforms in part of Kagan's opinion, joined by 5 other justices, but not Alito, Thomas, and Gorsuch. Kagan's pronouncements seem intended to guide the lower courts down below in deciding whether a statute's application to a type of platform or a platform's functionality is unconstitutional. 2 big points here. First, she made it clear that the editorial judgments of Facebook in its news feed and of YouTube on its homepage are constitutionally protected expressive activity, despite the Fifth Circuit's ruling that such decisions are only conduct, not expressive choices protected by the First Amendment. Kagan wrote that Texas's statute, quote, prevents exactly the kind of editorial judgments this court has previously held to receive First Amendment protection. It prevents a platform from compiling the third-party speech it wants in the way it wants, and thus from offering the expressive product that, in other words, the overall output, that most reflects its own views and priorities. And second, the court was clear that a state cannot interfere with the editorial judgments of social media platforms in the interest of leveling the playing field between liberal and conservative viewpoints. Such government manipulation, and we've talked about this before, the marketplace of ideas, is verboten. Kagan explained, and I quote here, it's not the government's job to decide what counts as the right balance of private expression, to unbias, that's her term, what it thinks biased, rather than to leave such judgment to speakers and the audiences. So with that, let's go to our panel. Larissa, I'll start again with you in this one. You had mentioned before the panel that while much of Justice Kagan's opinion for the court was beautifully written, it was merely dicta. And this was something that Justice Alito talks about. So a dicta means that it's not binding, correct? That it's kind of like a riff or a tangent. She's just going off on this. Yet Kagan found it necessary to reiterate those key First Amendment principles because the Fifth Circuit had given so little weight to them, right, down below. So now that the Fifth Circuit gets to hear the case again, it's a facial challenge. 2 things, and anybody can chime in here as well on this one after Larissa starts off. First, do you think the Fifth Circuit will give any credence or weight to the First Amendment principles Justice Kagan articulated, or will it simply see them as non-binding dicta and we don't have to follow that? And then second, how should the lower courts, this is a great question, I think, how should the lower courts apply the facial challenge test comparing unconstitutional applications with constitutional ones? Is this a purely quantitative measure? And how does one examine the broad sweep of a law's applications, given the vast and complex nature of a platform and all of its functionalities? It's probably will kill the rest of the time, but go ahead.
Simple questions.
Okay, let me try to be brief, and everybody else can weigh in too. First off, the Fifth Circuit is free to ignore the portion of the opinion where Justice Kagan and the other justices who join with her say that the Fifth Circuit really didn't give the right weight to First Amendment principles before. It's not bound by that. All it's bound by is to now go back and consider the whole scope of the statute, examine the whole scope of the statute, and compare the number of unconstitutional applications to the number of constitutional applications after you've explored that. I think there's like a poison chalice in there because the justices say, I don't know how you're going to do that. And I think that's something we really need to think about. This is a big old statute. It's got a lot of different, both of them, in Florida and Texas. And they're both different in some regards, similar in others. So there are these huge statutes. And so the Trade Association for NetChoice had counted on using a facial challenge. The idea is that a statute sitting out there and being unconstitutional mostly can chill expression so much that will allow you to challenge the whole thing on its face without the government ever like coming and saying, okay, you didn't give me an individualized explanation for everything you took down for your platform, and now I'm going to fine you. You don't have to wait for that. You can say, look, this whole thing is so blatantly unconstitutional, I'm going to strike it down. I think the Supreme Court's decision makes that very, very difficult to do now. I think you almost have to pick apart these big statutes piece by piece, each provision by provision, challenge them separately, because the court, several justices suggest, how are you even going to do that? This thing is so big. How are you going to figure out what its scope is? How are you going to have enough discovery and enough fact-finding and enough, and I really don't know the answer to that. And then there's a suggestion that this comes from the one of the concurring opinions, there's like a numerator and denominator. So you take the number of constitutional applications in the statute, things they got right, the state got right, and you divide it by the number of things they got wrong, and I don't know what fraction is going to cause it to be unconstitutional when the plainly legitimate sweep is going to be too much. It used to be, before this decision, that if there were just so many smack you in the face, blatantly unconstitutional parts of the statute, you would say, okay, facially, it's bad, get rid of it. They didn't even really try. The lazy state legislatures, they wanted to be performative in their legislation. They've got this blatantly unconstitutional piece of legislation, facial challenge, boom, it's gone. You can't do that now.
Yeah, we used to think of sometimes as overbreadth. That is another way of thinking that the law is simply overbroad. It sweeps within its ambit substantially amount of protected speech, along with that speech that it could legitimately regulate. They didn't use that term, but that's
yes.
I mean, overbreadth was clearly implicit here, although the terminology does matter in terms of how you phrase your arguments below,
Right.
and the fact that this didn't come up below in quite the clear way that the court might have expected also adds a wrinkle here. I mean, it's interesting to think about. Again, we're dealing with big sweeping statutes, big sweeping activities, right? And Justice Sotomayor, during the oral argument in NetChoice, says, this is so sweeping, maybe we need a different way to think about it. And that, I'm disappointed that didn't go anywhere, regardless of how it eventually affected the decision, because it seems like that's the right question to be asking here. When you're dealing with a law that's acting on this kind of scale, does the numerator-denominator concept, which comes from other cases, even make sense? Or do you just say, whoa, you're trying to do too much, go back, try again?
So I'll give sort of a half cheer for the court on this one, right?
Okay.
In the sense of, so I've read the arguments before about how facial challenges are unconstitutional, the argument that Justice Thomas makes, and it was the first time that it really kind of struck me as maybe there's something here. The court, the court certainly makes this case makes clear that having facts is helpful. And my judge, when I was clerking, always said we need to be careful to write as narrow an opinion as possible because we never want to close the door to a litigant before they come to the courthouse, right? And facial challenges kind of do that. That's Justice Thomas's concern about it. That having been said, facial challenges are valuable in rooting out the kinds of unconstitutional claims that nobody would dare to violate and then dare the state to prosecute, right? Abortion is a great example of those. When Roe v. Wade was the law of the land, right? Facial challenges were what were brought to with regard to state legislation that challenged Roe because you wouldn't want to wait for an abortion doctor to potentially risk his license, right? You want an answer before you have any factual development. So there certainly is a role for facial challenges going forward, but I understand the court's reluctance here.
And Clay, you also raised the question about what does the court below do with the First Amendment piece of this?
Do they ignore it, or they buy it, or they use it and say this is what's unconstitutional, this is not? Yeah. What do you...
I mean, I totally agree with Larissa that they could ignore it, and especially the Fifth Circuit. But I don't think they will, because I think the court actually gave them another path here, whether it intended to or not. So you mentioned there was a majority of 6 who agreed with Justice Kagan's First Amendment analysis. They lose Justice Jackson on applying that to these paradigmatic cases that you mentioned. Okay, so then you're only left with 5. Justice Barrett writes a concurrence which undermines her agreement with the majority, saying, yes, as to this theoretical construct on a partial record, I agree this is how it should be applied, but I'm not sure what will happen after the record is developed below. Maybe there will be these technological differences we were talking about, which make a difference here. And so I think more likely what's going to happen is that you're going to see the lower courts I mean, just about anything could happen. You could have NetChoice reframing its complaints as applied challenges and try to narrow it down or whatever. But I think what will happen below is that the states will look at this as a marvelous opportunity to take deep discovery into the technological details of how these systems work, putting pressure on the platforms who don't want to give up that kind of data, to try to dig in and develop a record that allows them to say, okay, well, even under Justice Kagan's analysis as filtered through Justice Barrett, we reach a different result. I think that's more likely.
So do you see this as almost now we get to find out how your algorithms finally work, that you've been you were keeping these algorithms so secret, right? And that's one of the other tensions here,
Yes.
right? That the algorithm does the thinking, there's no human, but we'll get into that, but right? But is that part of it?
Well, and Justice Alito actually calls this out in his dissent.
Yeah.
He writes about this saying, they were being awfully cagey about revealing this information, which they said was competitively sensitive, but I don't buy it. It seems like there's some skullduggery going on here about them hiding the ball. I'm not going to opine one way or the other on whether there was ball hiding going on here because they didn't like what it would do to the analysis. But I think at least Alito raising that question puts a big target on that for discovery below.
I think it should alarm us a little bit that Barrett gets into this dicta about different kinds of algorithmic editorial culling of content. Some might be protected by the First Amendment and some might not. It has enormous implications for defamation suits against ChatGPT, for example.
Yes.
And it's like total speculation. It sends shivers through. I mean, it could be a way of curtailing First Amendment rights and this right to receive. She also has some dicta about the TikTok litigation,
Right.
I was like, well, they're foreigners. We don't care about their speech rights. That I find a little bit alarming as well.
100% agree on both of those.
Yeah.
But this is not. I don't think this is. The appropriate is too strong a word. I'm looking for a better word. I don't think this is wise judicial behavior to write like you're a law professor writing a law review article with speculation about future technologies and potential cases that might come up.
Kind of to put this in perspective too, the Roberts Court in many areas, not all, has been known for judicial minimalism, writing those opinions that are minimalistic. These are not, in terms of justices going off and talking about TikTok. Clearly, she never mentions TikTok, but
No.
she mentions foreign ownership, I think.
Right.
And so clearly telegraphing that, when that case comes to us. And so I think it's interesting that, yes, there's in dicta, going off in dicta that's not necessary to resolve the case, but we're going to find it necessary because we don't trust the Fifth Circuit on remand, basically, to go look at it.
Yeah, and a couple of things on this. I mean, first, I think it's important to note that it wasn't just the majority doing this.
No.
Justice Alito
yeah.
was not shy about saying, okay, here are the principles I would apply, and here's how I would apply them to these circumstances which weren't before the court. Reddit delegates its content moderation to moderators. Does Reddit have First Amendment rights if it's delegating its moderation choices? That seems like a hard argument. It's like, okay, great, so now we get that piece of dicta coming into a potential analysis. Whether that's right or not, we are working very much in an abstract here. I mean, one other point I'd like to raise about all of this.
You're going to have to pay me $10. All right, go for it. Go. Just buy me a drink, Clay. Go.
You got it. So is that a lot of this discussion goes into the question of whether or not the platforms have First Amendment rights. Mm-hmm. And I think that's, in some deep and fundamental sense, misleading. Because what I think is more important here, but difficult to bring up based on how these cases were phrased, is the rights of the speakers and listeners on the platform. Okay, so for example, say that a state, pick a state which isn't involved in this case, Michigan. Michigan decides to pass a law forbidding Facebook from engaging in any content moderation whatsoever. Raw chronological feed, anything anybody posts, zips by on your screen. Very clear that would make the platform unusable, make the platform totally unusable, and be a violation of both the speakers and the listeners on that platform, because they're damaging the operation of the marketplace of ideas to such an extent that it's interfering with people speaking to one another. Now, do Texas and Florida go that far? Maybe yes, maybe no, but the point being here is that these kind of interventions it's not just about silencing what the platforms might have to say. It's interfering in how people are talking to one another at the user level. And that piece is very, very important here. This comes back to the question of whether or not, for example, Facebook can be treated as a common carrier. Generally, when we talk about communications common carriers, we're not talking about media of mass communication. Why? Because there is a natural limitation by virtue of the fact that we're human beings and only can take in so much information at a time in terms of what we're able to parse. So if you force everybody to get everything, very rapidly communication becomes unworkable. Right. So what's the solution? You need intermediaries making editorial decisions. That's not a flaw in freedom of speech that you have intermediaries making those choices. That's in fact the marketplace of ideas at work. And I know we were going to get to this later, but it seemed to fit.
Go for it now. Then I'll move to Daniel on common carrier. But yeah, go.
Okay, so the First Amendment does not presume that all ideas are created equal. Much to the contrary, it assumes that some people are right and some are wrong, and some ideas need to be filtered out. The editorial discretion at the mass media level is how we see the marketplace of ideas at work in terms of ideas competing for amplification, and amplification is key here because that's what's different between mass media and other kinds of common carrier, and well, other communications platforms which could be considered common carriers. You know, competing for amplification to a mass audience. And you know, we've seen that with newspapers, we've seen that, and although social media platforms don't engage in as much of that decision making, they have been engaging in some editorial discretion to block out stuff for as long as they've been in operation. And it is vital because that's what allows the marketplace of ideas to function with respect to the speakers and listeners that use them.
So it helps the audience, I mean, the audience benefits from all of because it's a winnowing, right?
Well, exactly. You're winnowing, the ideas get winnowed out. Now, in an ideal world, we'd all be able to take in all of the information that could come to us from any source and do this all in our own head, so there's nothing that we don't get exposed to. But, go ahead.
Well, this is kind of a side point, but I wanted to point out, if you say that, I want to think about it as a state issue. Texas and Florida, okay, they can tell you can't block certain kinds of content, and then you have to have individualized explanations for every piece of content you block, which is, that itself is just undoable. At the very same time, California and New York have statutes saying you must moderate certain kinds of content.
Yeah.
Okay, now, you're Facebook, you operate globally, you're subject to different legal regimes, but there's a problem here to the whole technology being useful for us as listeners and readers if they're like little walled regimes. By the way, in the Texas legislation, they had something that said, how was it phrased? They told Facebook, you can't respond to this by just pulling out of Texas. I forget what they did to enforce it. It was strange.
They said that you cannot discriminate with respect to content on the basis of the location
geography.
Of the speaker in
Geography,
Texas.
that's
Geography.
right. Yes. That's right. So they'll punish you if you try to pull out of Texas, and they'll punish you if you don't adhere to their law. But at the same time, you know, you're going to be facing California and New York, and everybody will get into the battle. And there's a federalism problem. It really is something that should be handled if it's going to be handled at the federal level.
Let me can I go to Daniel on this one, on the common carrier?
Yeah, I'm building just one. I think I can go one step further and just look at it through like an antitrust lens, right?
Yes.
If what you want is competition among the platforms, right? So Tim Wu describes them as attention merchants, right? They're all competing for your attention, right? You want different companies to experiment with different algorithms, right? To figure out what's hitting the best. The way markets develop is through trial and error, right? So you want Facebook to run its algorithm a certain way. And this is why I think the difference between human-centric or algorithmic organization, it's a distinction without a difference. What you want are these companies to experiment, see what works, and what's going to develop the most efficient algorithm to give the people the information that they want. And by the way, that may differ from platform to platform, right? Facebook tries to be the family-friendly platform. Twitter has some questionable content, but puts it behind a warning screen, right? 8chan, anything goes, right? And so people can opt into the platform that's going to give them the feed whose brand aligns with the kind of information they want. That's a good thing. And this kind of gets at the common carrier point, right? When you start applying common carriage, a one-size-fits-all model, what you're basically doing is collapsing those planes of competition. And that makes the market much less efficient in the way it gets the information that people want to the people who are consuming it.
And particularly in this era where we're starting to see decentralized moderation models through technologies like the Fediverse, and where if you're allowed to do it, you can have this tremendous explosion in different ways in which content is moderated and those choices are made. I mean, that strikes me as a great thing, not something that needs to be suppressed.
Final thoughts before we go to audience questions.
I just want to say, I think Elon Musk's purchase of Twitter, now X, really affected the outcome of this litigation in the sense that it emphasized that what you filter and what you don't filter is indeed very centrally a First Amendment exercise of editorial judgment that matters. If that needed better illustration, I can't imagine a better illustration. I think it's at the back of the justice's decision here.
And it shows that how a platform chooses to moderate may change over time, right? And the choices Daniel was suggesting, here's one option, here's a Reddit option, they're all different. So let me go to questions from, we have somebody at the microphone to, are we doing this just over here? Thank you. 1 second, we'll get the microphone. Go ahead.
JP Hogan, I've been on Twitter since 2009, commenting on politics, but too many questions, so let's narrow it down. First Amendment to the Supreme Court runs into the freedom of religion. If Congress can make no law respecting an establishment of religion, they're not really supposed to put God in the Constitution. God is in the Constitution, it's signed done in the year of our Lord, but that's like a vertical separation, putting the government also under. But more to the platforms, like at POTUS versus at real Donald Trump, seems at POTUS is like a postal inspector saying the mail must get through. At real Donald Trump, a property owner who's allowed to remove graffiti, a politician allowed to have a fundraising dinner with 10,000 plate dinners and preach to the choir. So it's fitting. Okay, there are too many questions in what I was trying to get to, but I've been involved in this for thinking about how I would post on it.
So have we. We do that all the time. It's fine.
But on the first, it's like how are they to decide the First Amendment as freedom of religion if the government's not supposed to make a religious decision? So if they're trying to be vague, are they keeping it that that's supposed to be outside, like using someone else's name? That could be a trespass for bearing false witness. So it could be using the religious terminology to say, well, there's no right to violate the commandments in the Constitution. They didn't write it in there, but is there? So I'll just raise some of the issues and let it filter.
No. I mean, I see the points about free speech and freedom of religion, and increasingly the court has tried to emphasize, I think, the power of the religion clauses in its jurisprudence from the praying football coach through. So, other question about either NetChoice or Lindke, Murthy.
Can I just jump in on this one? Because I think there's an interesting point here, which goes back to the point I was trying to make earlier regarding the central theory on which you're making decisions under these different pieces of the First Amendment. I mean, really, you need to go back to why, I mean, in my opinion at least, go back to why that piece of the First Amendment exists in the first place. Why do we have a speech clause? Why do we have a press clause? Why do we have a religion clause? Derive your rulemaking from those reasons. And, I think part of what we struggle with is reconciling the case law as it's developed back to those fundamental principles. So I'm not so much answering your questions as echoing that there's a way to think about this in terms of doctrine and legal doctrine. Yeah.
And that goes to that basis too, of the difference, I mean, the linkage should be there between theory and doctrine. The doctrine are the rules and the tests that we're talking about, and the theory is the underlying principles, and they should sync up. And your Bob Post has written about that notion that they should be synced up together. Yeah. Other questions? How about in the back?
Yes, my name is Roger Cochetti. I'm an editorial contributor on technology policy for the Hill newspaper. And as someone who's followed these cases and prior cases at a little bit of a distance, there's a logical gap I'm hoping somebody can help explain. 2017 may seem like a century ago, but in 2017, the court ruled in Pakenham that Facebook was a town square. And it's been years since I read the case, but it seemed to me, and this was Ginsburg, Thomas, Gorsuch, Kagan, everybody agreeing on this notion that Facebook was a town square. And I think they even used the analogy that said, if you have a shopping mall in a town, which is the only place where people can congregate, then they have a right to put up whatever signs they want on the outside, but in the mall, they're a town square, so they're subject to the rules. And this vaguely reminded me of what the EU has done to say if you're a gateway, then you're subject to different rules than, some little website operator. So the gap I have is what happened to Pakenham? I can't figure out. It seemed like they were going down, and was it explicitly repudiated? Did they say we made a huge mistake in Pakenham, forget it ever happened? Or
Do you want to?
does it still exist? Where's
I'll say,
Pakenham?
When I teach
Thank you.
Pakenham, I teach it as the unintended consequences of Justice Kennedy's rhetorical flourishes.
It is, totally, yeah.
And the interesting thing about Pakenham was a unanimous decision. It was 9-0, but it was 5-4 in the opinions because those 4 justices, including surprisingly Alito, didn't want to join that dicta suggesting that that Facebook is the new public square, right? So Pakenham was getting at a state restriction on a convicted sex offender, which I think is different than because that's the state restricting one's ability to speak, which aligns very well with First Amendment doctrine, even if the analogy to the public square didn't quite. What was a vestige of a long lost era, and that's why the random aside to Red Lion and Sotomayor's opinion kind of scares me because it's a throwback to an earlier era of First Amendment jurisprudence.
Yeah, so we were talking about undisciplined dicta, and I think that was the term Alito calls it, undisciplined dicta in that case, going off on the tangent, and that had nothing to resolve the case. So Pakenham basically was banning registered sex offenders from accessing social media platforms, as I recall.
Where they could find children, I think, was the
right. And so, but that was essentially an example of a law being simply far too broad because it banned them from all types, the Washington Post, NewYorkTimes.com, whatever it would be. And so when Kennedy wrote that language, he didn't need to put that in about this is the new town square. And, and so, like you said, it's Kennedy's glorious dicta coming back and...
He's writing for law professors. He wants to be quoted. I think the lesson, to answer your question in a different way, I think the lesson of the NetChoice case is that the Supreme Court has realized that Facebook contains multitudes. But if you want another inconsistency, in Twitter versus Tamna, just from last term, which was about should Facebook, YouTube be responsible for aiding and abetting terrorism when people get radicalized by watching stuff. The algorithm feeds them stuff that might radicalize them, and this court said no. And in there's language that treats them like conduits, dumb conduits, basically. And so that flatly contradicts, but I think the right answer is that as the internet's matured and the court's relation to it has matured, they've realized you can't make one pronouncement for all cases because it's just too complex social.
Did they repudiate Pakenham or?
No, because the underlying ruling in Pakenham doesn't rely on the language you're talking about. Yeah. It's because the case involved a government actor, the state, banning access to Facebook. And whether or not Facebook is the new town square or whatever else doesn't change the outcome of the case.
It was just simply the law was too broad, basically. Yeah. Questions? Yes.
Good question.
In front. Thank you.
My name's Ann Vroom. In all of these 3 decisions, I was surprised that Section 230 didn't come more into play. For both sides and all the litigation, how it was framed, rather than the free speech, to tell you the truth, because it seems to me that 230 could arguably be, you got a privilege, a protection against litigation. However, the quid pro quo for that was you stay neutral. The minute you start modifying, or moderating rather, and making editorial decisions, you've abandoned that almost common carrier neutrality. You now aren't just delivering the letters, you're opening them and you're deciding which ones you're going to deliver. So couldn't you conversely argue, well, you've lost your 230 protection because your 230 protection or privilege against litigation was predicated on this neutrality? That's my question.
It's a great question, and that's what Texas wanted people to believe, I think. Texas wanted to see that you're no longer going to have this. You've been granted this Section 230 immunity because you're like a common carrier, and this is going to go away. We also saw, I mean, lurking in the background again, Section 230 in Murthy versus Missouri, that we're going to revoke this from you. So although it was not a direct issue, I think it provided a subtext. I don't know, what do people, anybody?
I mean, the question of what Section 230 was intended to do is one that has been long debated. The overwhelming judicial consensus, but I won't say unanimous judicial consensus, is that Section 230 does something a little different. It creates a protection that would not have existed because these platforms these intermediaries are not acting as dumb pipes. Had they been dumb pipes, common law protections around liability for content would have applied here. They wouldn't necessarily have needed Section 230. Section 230 comes into the gap because of this imbalance that Larissa was talking about earlier in terms of the interest of intermediaries in the speech they carry. It would be too easy, for example, to be able to threaten Twitter with a defamation lawsuit because of a user's post and get them to take down that post regardless of whether the defamation claim was valid. Because Twitter has so little investment in any particular post that the far easier solution is just take it down rather than risk liability. Now, I'm glossing over a huge amount of legislative history. I'm glossing over a huge amount of, and I apologize for that, for those of you who might be Section 230 savvy in the room. Please forgive me. There is substantial legislative history around the time that Section 230 was passed, indicating that the more prevalent interpretation among the courts was what was originally intended. But I'll stop there. The bottom line is, yes, you're making an argument which has been made around Section 230. I'm not sure it's consistent with with the pre-existing framework in which Section 230 was being passed as to whether such a law would have been necessary.
I think that's exactly right, and I would just add two things. One is that there are two parts to Section 230, right? The first part is immunity for what users post, and the second part is immunity for if you choose to take down a user's post. And both of those were meant consciously to work in tandem. The other thing is that NetChoice has brought a claim that Section 230 preempts the Texas and Florida legislation, but the court hasn't moved forward on those yet.
And with that, I don't think was it even ruled upon by the courts of appeals?
No, I don't think so.
Or dormant commerce clauses
Also
under
an issue,
there to say that it needs to be a federal issue, basically.
And we are out of time. So thank you all very much. And the next panel starts right away, I believe, right? Right?
All right, welcome back. Thank you guys for sticking with us. Wasn't that a great panel? I feel like getting to work with Clay and Daniel and then getting to meet the other two lawyers, they were just having such a fantastic time up here. So we will do a little bit of a recap because I know everyone on this panel would have loved to have been on that last panel, and they were nice enough to say they would stick around. And we also have Kathy Gillis joining us from California, so she's the person on the screen over here. I'll do some quick bio reads, and as my friend Jennifer Huddleston over at Cato says to her law students, if you use AI, that's fine, just let me know. So I thought it'd be kind of fun. I just threw your bios into Claude this morning to see if it would zhuzh them up a little bit. And it gave you little, I thought it did a pretty good job. So Ari Cohen said, you're the digital free speech crusader. From courtroom battles to online forums, Ari Cohen has been on the front lines of protecting free speech in the digital age. As free speech counsel at Tech Freedom, Ari navigates murky waters where the First Amendment meets the internet. With background that reads like a legal thriller, defending students' rights, talking on multinational cooperation, and the championing of individual freedoms, Ari brings a wealth of experience to fighting online expression. Whether he's untangling complexities of intermediary liability or standing up for controversial voices on campus, Ari's passion for free speech is anything but intermediate. So, people want to know what you can do. I know, you can have it. Kathy, you are next. You are the tech-savvy legal maverick. Imagine a lawyer who speaks fluent HTML and can argue a case in binary. That's Kathy Gillis, a rare breed of attorney who can bridge the gap between Silicon Valley and the courtroom. With a past life, a globetrotting webmaster, Kathy now yields her keyboard and legal pad with equal dexterity. Her cases read like a cyberpunk novel, defending anonymous bloggers, battling for college webcast rights, and taking on no less than the NSA in the name of internet privacy. When it comes to the collision of law and technology, Kathy isn't just ahead of the curve, she's coding the curve. Not too bad?
I can live with that.
Okay, you can live with that? All right, fair, all right.
I don't speak binary quite as fluently, but the rest of it seems okay.
It was the cyberpunk that really got you interested, I can tell.
All right, and can we work on
I really want to have the life that it thinks I had, but okay.
Okay, all right, well, I actually went back and kind of checked it against your bio, and I was like, maybe it knows more about Kathy than I do, I don't know. Todd O'Boyle is a tech policy ringmaster. In a three-ring circus of technology, policy, and progress, Todd O'Boyle is the ringmaster extraordinaire. As the Senior Director of Technology Policy at the Chamber of Progress, Todd juggles the interests of academia, civil society, and industry with the finesse of a seasoned performer. His career trajectory reads like a tech enthusiast bucket list, from shaping Twitter's approach to elections and information integrity to pioneering Lime's government relations in a wild west of e-scooters. With Todd at the helm, the future of technology policy promises to be anything but boring.
Congratulations, you're president of the circus.
And Kara Bodner is a state-level tech policy whisperer. While others focus on the bright lights of Washington, D.C., Kara knows that the real action in tech policy often happens at the state capitals and city halls. As state policy director for the Computer and Communication Industry Association, Kara is the secret weapon for navigating the labyrinth of local regulations. Her background is a unique cocktail of number crunching and politicking, from evaluating tax incentives with the Pew Charitable Trust to building a nationwide network of policy analysts. In a high-stake game of state-level tech policy, Kara is the ace up CCIA's sleeve.
Wow, it really thinks you're the most professional.
Thank AI for that.
Very good.
So knowing that,
he's a circus master.
Right, you know who our group is. Let's do just some revisiting of the last panel, because I know you guys are all chomping at the bit to talk about that. So looking at the recent Supreme Court decisions and their implications, how do you look at the court's interpretation and how it's going to be managed by the actual social media platforms, especially as it's been called out as a modern public square, as it influences the balance between free speech and content moderation? So a light topic. Let's just kind of recap what they just talked about for the last hour and a half. And Ari, I'll start with you.
Hard to say, but I do think one thing is clear is that the main thrust of the Texas and Florida laws are not going to survive. There might be some applications that survive, against whatever Uber Eats or what have you. But while a lot of that opinion technically is dicta, it also shows how the justices are thinking about it. And they had enough justices to get that in the majority opinion. So I don't think whatever the resolution on the facial challenge issue is, and this was kind of like the most annoying potential outcome, is that they did exactly what they did. I think it's pretty clear how the court is looking at this in terms of the large social media platforms. The thing that I found interesting, which is something that the last panel kind of went into, that I was glad I wasn't too far afield on it, was Justice Barrett's concurrence in NetChoice. And she said in almost consecutive paragraphs that if the platforms, say, want to not carry a particular candidate speech or speech about a candidate, and they created a, an algorithm to help them identify and remove that content, then that would clearly be fine. And then like a paragraph or two later, she said, but what about if they hand over the reins to AI and an LLM makes the decision on what's hateful? I mean, to me, that is like a classic exposition of justices wading into things that A, aren't before the court, but more importantly, B, they don't know like what they're doing, what they're talking about, because if Justice Barrett maybe had been briefed on this, she would have known that AI systems, LLMs, don't just spring up out of nowhere and make decisions about what content is hateful. They go through intensive training, and increasingly the dominant method of doing really that training is reinforcement from humans. So the platforms, the AI companies, are having people review the AI decisions and mark them as good or bad to help train them. And that is the part that is expressive. They are telling the LLM how to determine whether something is hateful. And to indicate that that is somehow not protected by the First Amendment, that's not expressive. It's kind of like saying, well, you told the computer by pressing on a keyboard what words to present on the screen, therefore it's not really expressive when the computer does it, which doesn't make any sense whatsoever. And it's kind of just bereft of like reality. So that part concerns me, and I'm hopeful that maybe when that issue comes up, there'll be better briefing on it that will help them understand it. But that's the part that really stuck out to me. The First Amendment, jurisprudence in the majority opinion was, is sound. And it's good that they were not backing off of that, and especially good that they seem really tired of the Fifth Circuit's shenanigans. Gives me a little bit of hope for Free Speech Coalition versus Paxton. But overall, it was the most annoying possible outcome, but it wasn't the worst possible outcome.
I mean, I might call it I would call it a win. I'm very, by and large, I think what the Supreme Court did on the First Amendment this term, with the exception of the IP cases, is good. I'm glad to have these things in my tool belt to go to battle with any of these other issues that show up. But to Art's point, is correct. It was a win, but it was needlessly messy. And we're going to be spending all of our time dealing with the mess that they created. And the problem with the mess is we've got really strong language to cut through it. Let's take, those AI examples and apply First Amendment doctrine to them. I think we get to the right answer. But because it's so messy, the chance that people will get lost and decide something else is needlessly high because they've created this risk. And we're already hearing it because we'll talk more about some of the other litigation that's percolating in the lower court. And last week, 2 weeks ago, there was some Ninth Circuit hearings where they completely sold on the First Amendment doctrine, but then are like, are we allowed to actually rule in your favor because of the mess on the facial challenge that the Supreme Court had made in its decision? So all of a sudden, the prize was accessible. We actually had some really strong First Amendment to shut down bad activities to try to censor online speech, and the punches are getting pulled because of extra procedural complications that really are kind of needless and shouldn't be there.
Yeah, Merritt's counsel is the one who got hosed the most on this one. They're going to have the most irritating job for the next few years.
Yeah, I think, at CCIA, we're excited to see how this, does resolve itself in the lower courts. I think everybody's expressed some slight frustration in this being a little bit of a messier outcome. But I do think that the panel previous to us did a good job outlining some pretty big themes. For example, how allowing digital services to have editorial discretion does contribute to a more robust marketplace of ideas, and some of the signaling to the lower courts that should really be considered in terms of having that editorial discretion and differentiating these digital services from other common carriers. So I think, especially as somebody who's in the weeds on a lot of the content-related legislation across the states, I think it's been talking about these cases moving through the judicial system has been one of the things that we've been raising with lawmakers as other states outside of Texas and Florida have considered similar proposals. And I think that while this decision again could be a little bit messier than we might have hoped, I think this will continue to signal to lawmakers that this is a complicated matter, and but I think the overall message of being able to maintain that editorial discretion is really important. And I especially appreciated the point from the previous panel in talking about how the positioning of states like Texas and Florida are very different from states like New York and California. And especially for these services that are operating across state lines, global boundaries, it puts those services in an untenable position of trying to comply with disparate and very conflicting laws if this is the approach that we take to it.
Todd?
Well, I think that the real takeaway for me, at least at Chamber of Progress, is we're looking like Kara to some of the state-by-state developments and how this is already impacting various state legislative proposals to regulate online platforms. I think there had been very good arguments, very defensible arguments that and strong case law to cite that the courts are very skeptical of many of the mechanisms by which states were variously looking to regulate content, regulate feeds, regulate the sort of core curatorial and editorial decisions of social media platforms. But I feel like the NetChoice cases really hit that home in a way that really, it's increasingly hard to hide behind, oh, we're just regulating design. It's increasingly hard to hide behind, oh, we're not regulating content, we're just regulating conduct. And I think that if there were any sort of argument to make in that regard, I think the court was quite clear that this is expressive, that these are fundamentally expressive decisions, and attempting to regulate them is going to be very difficult. I think there are clear implications at the state level, again, not merely in Texas and Florida, but also in places like New York, which recently passed its Safer Kids Act. California has a comparable bill in the legislature pending right now, as well as several other initiatives at the state level to regulate particularly minor access to protected speech. And I think this is just going to be a very difficult road for legislators, no matter how well-intentioned they might be.
So how are we, now that we've had the courts come out, how are we seeing the impact on both innovation and investment? And so those are two areas that, and especially because we're seeing so much more state activity and not so much at the federal, are people feeling, was there enough comfort level in what the court returned, or are they still feeling like there's just more leaves to fall off of this legal tree?
Well, since you mentioned that, one of the proposals that we've really had our eyes on concerns liability in the state of California, liability for online content from Lowenthal's bill. And I think it is really difficult to square ratifying that and any sort of liability for content with not just Section 230, but also the clear decisions that came down from the series of NetChoice cases. So I would hope that this is removing some of the uncertainty and allowing innovators to continue to innovate. I should also note that because algorithms are how platforms protect young people, that if this allows if these cases make clear that regulating these sort of core curatorial and editorial decisions is contrary to the First Amendment, therefore regulating algorithmically promoted content, which includes the protections against cyberbullying, includes automated content removal that protects young people from being victimized, that those two are going to be unconstitutional. And let's not legislate that way. Let's make it clear that platforms can and should continue to invest in improving their products in age-appropriate ways.
Yeah, I guess it's worth noting, the reason why it's hard to square some of like the NetChoice decision with some of these new liability things. It's a for people who aren't knee deep in First Amendment law all the time, it seems to make sense. The government's not restricting speech. You're just liable if your speech hurts someone, and that might be true in some cases. Like some particularly egregious instances of defamation, but generally speaking, there's a First Amendment issue whenever there's tort liability because of the effects of speech. And just to give like a quick background so that it's a little bit more fleshed out, there have been cases since the 1940s, I think is the earliest, maybe the 1930s that I found, about negligence liability for speech. So you wrote this book, I got a bad idea from it, and I did something and I hurt myself, you negligently said that, and therefore you are liable. And the courts have held that imposing, but in tort liability, you need generally a duty of care. And the court said creating a duty of care for speech would reduce the speech of everyone to the most safe, boring, anodyne speech, because everyone would be worried about some silly thing happening because of something they said or someone getting the wrong idea from it, that would chill speech so much that we are not going to impose a duty of care. And that line has held remarkably consistently for nearly 100 years now, maybe even 100 years if I haven't really gone too far back. But one of the problems with all of these laws is they do exactly what the court have said you can't do, which is impose this duty of care. And the duty of care is not any more constitutional because it's statutorily imposed than just under the common law. And it's particularly galling when they try to argue, well, we're doing liability for the design choices. Well, if that design choice is the content that your design choice serves, then it is inherently based on the content. You can't divorce those two things. It's like saying we're imposing liability because real estate is Section 5 in the newspaper, and that's your design choice. It's not consistent with anything. It's a way to it's a legislative attempt at pleading around, and it doesn't work, and it's not going to work, hopefully, and it's really it's dangerous because from the broadcasting cases where kids would watch movies that involve violent crimes and then imitate them and then try to hold the broadcast stations or the studios responsible, to the book that told people to eat mushrooms that they really shouldn't have eaten, or at least not without cooking them. It's very broad and very clear that we're not going to impose liability just because someone saw speech and something bad happened as a result.
And it needs to recognize how expressive design choices are, which tend to be completely overlooked. But if you're a bookstore owner and you've chosen which book to put in your window, that is an expressive act. And sometimes you just have to, I think there's people who, it may be easier to see in the offline space, and like our job as advocates is to pull back and say, this dynamic that you're seeing in this offline context, this is the correct analogy in the online context. And then that's our job. And then it just gets complicated when people introduce inapt analogies, and then we have to pry them away from the inapt analogies and get them shifted over to the correct ones.
I don't think I have a ton to add on this front, but I do like the conversation about how using offline and online analogies, I think it's a good exercise to go into, but I think it also can be dangerous. Like one of the things that drives me absolutely crazy is in talking about some of the online safety related issues and age gating and things of that nature. The conversations about, well, you go into a liquor store to buy alcohol and you need to show ID to do that. And I'm like, yes, but that's not a protected activity. Do we dare forget about prohibition? We actually banned that for a long time. But also, I think, again, in the context of, if we're going to age gate the internet because of these perceived harms, I think that we talked about how broadly sweeping both the Florida and Texas laws are. A lot of these safety-related bills are also broadly sweeping. And it just makes me think of using the alcohol analogy again. I think that there's also many studies out there talking about potential harms of alcohol consumption, but we're not going to bars and saying, not only are you going to age gate this, but you are going to cap your serving to each individual at 3 drinks per person. So using some of those analogies about, how the duty of care or like the level of government stepping in on these issues, one, the analogy to alcohol is probably not fair, especially in the offline context. But also, if we're talking about the studies about harms, there are plenty of things that we have in the offline space that have harms associated with them, but we're not taking the same blunt approach to addressing those perceived harms.
And the worst one is actually cigarettes. If you can look at Facebook or a social media platform, which is basically, and say that this is causing harm because of the content of speech, and think that that is directly analogous to a product that when used as intended will invariably kill you physically, and you can't understand the difference, I'm not sure if you can be helped. I mean, the differences are so stark and so obvious that it's really, I'm left to conclude that the only thing that is being done by using that analogy is not making any kind of real argument. It is trying to trade on the vitriol that the tobacco industry had to encounter, and not having to build it from scratch, but just redirecting it over, because then it's a lot easier to do, and it's a lot stronger of an emotional impact. It's it's a rhetorical sleight of hand that it's effective, but totally bogus.
And to add on to my earlier comment, it's not just that design needs to be seen as expressive, but all of this online activity needs to be seen as expressive. And I think people are struggling with it, that the online world is people talking to each other. And essentially what the government is really trying to do is say, stop it, stop talking to each other. We don't want you talking to each other because we think that if you talk to each other, it might be bad for you. But that it's a really much more direct assault at people talking to each other than I think is being recognized. And there should at least be some honesty that that's what's actually trying to be attempted.
Well, some people are coming out and said, there was that article a couple of years back, this is all happening because we're talking to each other too much, which I'm not really sure how you write in like the Atlantic with a straight face, but.
I think Kathy makes a really excellent point and well said, because ultimately the impacts of any of these potential regulations are very human and very real and very personal. And if you take something like a seemingly innocuous proposal to require something like parental consent for a minor to use social media, even if I were to assume charitably that it's well-intentioned, it's also true that you have the challenge of, say, LGBT youth that may live in unsupported households. Polling shows that 40%, 41% of adults say they would rather limit their minors' access to any LGBT information on the internet. I can only imagine what it must be like to be a youth in an unsupportive household. When the one place you might be able to find connection, the one place you might be able to find support and community and someone who accepts you for who you are is on the internet. But your parent says, no, you're not allowed to use the internet. A state law says that I can deny that to you. It just seems awfully regressive, awfully harmful to young people. And I hope that through conversations like this, and Kathy's great point that these are ultimately very human interactions, but these isn't just this isn't just a legal discussion, this is ultimately a very human one.
Well, and there's, I spoke with someone just the other week who runs a nonprofit organization about responsible homeschooling. And what she was telling to me was, there are kids who are out there in abusive households that are being homeschooled, and they don't even have anyone who can tell them that what they are experiencing is abuse. And just imagine that for a moment. Like, it's terrifying. And people say, well, the parents have a right to restrict their kids' access to information. Sure, that's true. But what they don't have a right to is have the government's help in doing so. If you want to do that, my perspective is, if you want to do that, I don't think you should do it. But if you're going to do it, figure out how to do it on your own.
And one of the things also, the position that we're taking is not a novel one. We're not saying, oh, it's something new that kids should have First Amendment rights. This has already been found. It's not necessarily been well supported consistently. I've got some issues with, I'm not a fan of the bong hits for Jesus case and things like that. But but it's not new to say that even people younger than 18 have First Amendment rights. And when you get these state proposals to like age gate, you are impacting the First Amendment in a number of places, not just one place. You're going to affect the right of internet users, including the younger users, but not just the younger users. And you're also going to affect the First Amendment rights of the intermediaries as well. So there's First Amendment violations all over the place. This is not innocuous, even if people think that it is. Oh, we're just making a small regulatory ask. It's a huge regulatory ask with a huge constitutional footprint.
So since we're already kind of heading down that path, on balancing free speech, platform responsibility, and users' both rights and safety, are we continuing to see the unintended consequences from these rulings, especially at the state? And with content moderation, I guess we are still battling the complete immunity versus full liability in the middle road there. Are we seeing, especially, I'm thinking at the state level, where one of the things that came to mind when you guys were talking is a friend of mine, God love her, takes care of people as they come out of being incarcerated, and she kind of has to know what year you were incarcerated, and then she'll be like, well, since you've been in, they've invented the ATM machine, right? Seriously, she has to explain to them and catch them up on so much technology that it's one of the multiple ways that it's frightening for them to re-enter. And I'm thinking of some kid going to another state school, and they're like, hey, you came from such state, well, let's get you caught up. What have you not had access to along the way, depending on how things are going? So I know that's a lot in that question, but
that's exactly one of the huge issues with this is, if you're going to cut off kids from social media until they're 18, there are some bills that would do that regardless of parental consent, which not only pose First Amendment problems, but also some due process problems in terms of parental rights in itself. If you're going to do that, but you also acknowledge the central role that that social media plays in our modern life, what you're doing is you are raising a bunch of people completely and wholly unprepared to actually participate in the life that they now have to participate in. And that is very silly, not just from like a normative level, but also like economically, that's disastrous. That puts us behind the curve in almost every sense. It's nonsense. And I'm reminded of a quote from Justice Posner's opinion in the Seventh Circuit case over the violent video game arcade law, an American Amusement Machine Association, whatever, Kendrick, I'll call it Kendrick, where he said, when you're 17 and a half, you're going to be able to vote in 6 months. How could you possibly be expected to do that if you haven't been able to participate in discourse until you're 18? Like that just, you're shoving these kids out into the world they're not prepared to deal with.
I think that's a great point that Ari makes. Like, there's not like a magic switch that flips like when you turn 18 years old, or whatever the age may be set by these specific states. But especially in a world that is increasingly connected and relies on being able to navigate these online spaces, I feel like it's very important to be able to, one, know how to access resources and communities that you want to be able to access online, but at the same point, be able to maybe navigate away from the ones that you don't want to be participating in and are not beneficial to whatever you might be wanting to engage in or learn from. And so if you're not, it reminds me, and not to use the analogy of like, if a kid who's been sheltered all their lives and goes to college, there's, the more you make something taboo, the more appealing it is once you finally have access to that. I think about like when I was growing up, the kids whose parents never allowed them to watch TV, they would come over and then be fixated on the TV for 6 hours at a time, and you couldn't pull them away from it because it was this new, brand new, like shiny thing. So I think there's as much value in being able to like learn, both the good and the bad of what's out there and being able to navigate that rather than just assuming that, all right, you turned 18, now you're ready to be in prime time and see it all.
Well, also like the whole one of the huge problems is there's no when you're saying okay, no kids under 18 or 16 on social media, that actually is just completely antithetical to every bit of like development that we know, because there's a drastic difference between a 16-year-old and a 12-year-old, and if you're just going to make that cutoff at one point, well, you're doing a huge disservice, even by your own standards, to all the kids right up against that line.
I think the words that really jumped out for me in your question were unintended consequence. And when I look at the state level push, for example, to legislate age-appropriate design codes, I think the bottom line reality is that they, if ratified, and some of them have been, over our rather strenuous objections, but if they have the force of law, then social platforms face this really just awful dilemma. If I host any content which may be deemed harmful to minors or variously, like if I don't satisfy a hazily defined duty of care, I'll face some kind of legal consequence. All too often, that social media company is going to decide, I'm just not going to bother. I'm going to remove all that content. That forum for and anything that might be remotely controversial, no matter the actual content of it, no matter what's actually there. So, you look at something like a forum for substance abuse, people that are struggling with substance abuse. From the outside, it might be difficult at first glance to tell the difference between a forum that's helping people work their way on the way to recovery and a forum where people are not and are engaging in maybe suboptimal behavior. But rather than touch any of that controversy, a social media platform is probably going to remove all of that content, deny that entire space, good and bad, and just to avoid the risk of legal consequence. And it take any issue it's remotely controversial and might stir the sort of anxieties or get the get an animated attorney general exercised. I mentioned eating disorders, but it could be anything related to gender affirming care or reproductive health information, or you name it, that those critical online spaces, often the only place where someone might be able to find their community and find their home online, they'll just be moderated away. And I think there's no way that you can, again, no matter the intention, no matter how well intentioned, there's no way you can pass a law like that without acknowledging that there are going to be really very real consequences for the total content of constitutionally protected speech and the total that'll be available online, and the number of critical resources that our most vulnerable members of society will have access to, above all, vulnerable youth. So I'm going to go ahead and assume that's an unintended consequence and not the explicit intention, but I think it's an inescapable consequence.
You're more forgiving than me. But what you actually said just is really important, because there is the conceit of this all is saying that companies should be more socially responsible, and then trying to influence that by attacking their business interests, which they presume will always come first, and presuming that the government's going to be able to actually successfully do that, which, if you've paid attention to government over the past ever, is more or less impossible.
I mean, what regulators don't seem to realize is that there's a basic physics to regulation, that things don't happen in a vacuum. They start knocking over dominoes, and there's going to be some logical consequences to something that you do. So even if you have a regulator who's modest and humble and says, I only really want to take this little small step, they need to recognize that that small step is going to, there's rational actors who are going to react in rational ways, and they really need to anticipate what they are because they're not really a mystery. You can look for the chilling effects and you can anticipate the chilling effects. And having a lawmaker say, no, 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 I didn't mean to do that, so therefore this shouldn't be a consequence. It's not practical. And so for whatever we end up talking about, the age gating, that regulators are trying to do to regulate online speech, age gating, mandatory transparency, any of the other design, whatever they want to do, even if they do something small, it will end up having a big effect. And if you don't look at what those effects are going to be and try to anticipate them, that's not good regulation because it means you're going to hurt more than you intended to hurt. You're probably not going to solve your problem, and you have a big constitutional injury. And it sort of makes why we have the First Amendment and why the First Amendment has to apply to online spaces as strongly as I think it does, and even the court is now saying it does, is so important because it helps forestall really dysfunctional regulation that ends up hurting more than it helps.
Did you want to add?
I just want to add 2 points. One, in response to what Todd was talking about with regard to the age-appropriate design codes. I think one of in his conversation about the unintended consequences and the chilling effect that would have, I think it's important, especially in these conversations, to acknowledge that while the age-appropriate design codes have come out of the UK, and one of the things that we hear so often is that, well, the internet still works in the same way in the UK, so it should be fine here too. But in the UK, obviously a different legal structure, period, but also the way that the age-appropriate design code in the UK is, it's not enforceable in the same way here, so we would anticipate that there would be more of that chilling effect and unintended consequences here in the US. But also to the point about trying to impose this type of social responsibility on platforms, I think that also, given that it's coming from politicians who have their own political agendas, there's likely to be a very, a wide variation in what that type of regulation looks like and what the expectations are when those laws are enforced. So I think it's a slippery slope.
I'm quite pleased that the Ninth Circuit did, in the hearings the other week, kind of recognized to some of California's argument to say, well, we modeled this off of laws in England. They're like, hello, this is the United States here. That's not going to really help us out.
Yes. So let's I want to bring the parents and the guardians into this. And because you've brought up, we've talked about age verification and design code. And I would imagine that these are not businesses that want to be harming their customers, right? So along the way, and I love going in and playing with all the tools because half the time I'm like, why do they just leave these for the kids? I want to, that'd be great. Time out, I put myself in timeout. So do you think there is space for the parents and the guardians to take appropriate care of their children in the way that these, especially state laws, are being designed? I mean, is there an idea that nobody's looking to go out of their way here to do really bad things, that we're putting tools in place, and are we getting any feedback on those? Because I know sometimes I always say a joke, it's like privacy law that, it's on page 36, I just didn't read far enough, But are the tools that are coming in place, are they iterative? Are we learning? Are we finding as things are coming along that there are ways to say, take a break? And I do notice these things, but I also spend a lot of time with Meta, and they tell me about them, and then I notice them. So it could be also a self-looking ice cream cone.
I mean, I think, first of all, I've always said, if you want to give resources, if Congress wants to give resources to educating parents about tools and encouraging platforms to develop new tools, I am all for it. But what I hear, it's never enough. It's not going to be enough until those tools can prevent 100% of whatever any particular person is worried about, which is obviously impossible. And I just hear, oh, well, it's too hard. Well, I mean, parenting is difficult. That's nothing new.
It's too hard to be a parent. I thought you meant it's too hard to be. It is. Well,
yeah,
no, the parents
they're saying the parents don't know how to use it.
But we're trying to make sure they've got the tools there. I mean, of course, we know the people that really know how to use the tools are the kids, right? Because they're going to be like, Dad, I don't have time. Here's a YouTube video. Watch it. Come back to me. We can set my things, which then I will just change while you're not here.
I do think there's definitely a challenge, because I know in having conversations with policymakers, we do point to the number of tools that are available at the various levels, whether it be at the application level, at the device level, different settings that parents can use on routers, on browsers. And there is often that response of it's just too hard and the kids know better than we do and they're going to find a way around it. But I do also find the frustration in, talking with policymakers and attorneys general, and then the asking like, well, there are these tools available, and they acknowledge the tools are available. And then I ask the question, well, what else would you like to see? And I get well, these companies have the smartest people in the room, they should figure it out. But
Nerd harder.
Exactly, the nerd harder response, but there's not actually, it's hard to understand what expectation needs to be met if the expectation can't be conveyed. So I feel like that's kind of puts in the vicious cycle of like, well, what is going to be enough then? If
Make them be transparent. Transparency reports, mandatory transparency, or then reflect back a mirror that say this is what's wrong when you have those requirements that mandate transparency. Because isn't it really hard to sort of figure out and articulate what's going on deep inside your skull?
Okay, we got to vote for transparency. 2 votes. I vote for it too. So the implications on age verification requirements on online platforms bring a lot of things up. And one of them is privacy, because I think you end up gathering more information to want less information. And as another colleague in this space mentioned one day, he's like, once you collect data, it's collected. There's no getting rid of it. And that thought has not left my head since he said that, because I'm a big believer that you should only take in as much as you need, knowing that some cyber criminal is very excited when you're just combing through all that data. So how is there a middle ground through all of this? I mean, I get your point. The UK has different laws. They're riding to a different standard than we are here. But is there any tools that you've seen that you think are actually applicable, or are we still in the we haven't found the right space to find middle ground yet?
I think it depends if you talk about age verification or age assurance, because one thing people should be clear about is if you need to verify age, nothing other than hardcore proof of age and identity is going to work. But also, it's hilarious to me that people say, well, kids are just going to find a way around parental guidance. Well, what makes you think they're not going to find a way around age verification? Because it's easy to take an older brother's ID and sign up for an account. It's also easy to trick selfie verification with free software that you can find on the first page of the Google results. If you're thinking, oh well, kids are just going to get around one thing, then what justification do you have for thinking they're not going to get around this other thing?
It's also ridiculous to call anything a privacy bill that requires collecting more data. And we've actually been putting up with this for far too long, because we can go back to COPPA, which required, it's insane that, okay, we've got cybersecurity problems, there's hacks everywhere, and everybody's got all of our personal information, including our birth dates. Well, why did we collect the birth dates? Because it was part of a privacy regulation? We've created honeypots of data, and the solution to better privacy is not to extract more data that can then end up in more people's hands. It's nonsensical. It's nonsensical, and let's frame it as dangerous. And then also we get into the point of when it comes to speaking online, you're supposed to be able to speak privately, including to the point of anonymously, and all of these bills would trash the First Amendment protected activity of anonymous speech. And that is yet another one of the First Amendment harms that these bills tend to cause.
That's a really key point, because the cases, the Reno case is that kind of established this jurisprudence of age verification and anonymity really only dealt with the right to receive information. The problem is so much worse, like you said, when it's not just a bar on accessing controversial information, but actually speaking. The problem becomes even more severe and more obvious.
I think I would also, I would say Kathy said it better than I ever could, but I think if you were to sort of bifurcate things a little bit between the state level and the federal level. The state level, you see things like Kansas passed an age verification law that said if anyone's going to access material, quote unquote, harmful to minors, you have to first verify the age of a user to do so. If you look up by reference to harmful to minors elsewhere in Kansas statute, it includes a bolded list of things that are per se harmful to minors. One of them is homosexuality. That, to me, speaks to just how regressive and how awful these proposals end up being in practice, even if you can, again, charitably assume more positive intent, which is maybe more charity than is called for. But stepping away from the state level and looking at the federal level, there is no way to both advance privacy and so there's no way to look at age verification in a way that is also data minimizing, and it runs contrary to the principles of data minimization at a time when many people believe that technology companies have too much of their personal data as it is. So those goals are inherently and inevitably in tension. I bring all this up because Congress this week, the Senate this week, is set to vote on a bundle of bills between COSA and COPPA 2.0. And I would certainly hope that they would keep some of these lessons in mind, that these nebulous and hazily defined duty of care standards, that these overly broad grants of authority to, say, a future regressive FTC to police what is safe online for children, there are going to be awful consequences if any of this comes to be the law of the land. And I would certainly hope that, if nothing, this discussion would give pause to legislators as they deliberate over this.
Not for
And
nothing.
it's nonsense because they just did TikTok. We banned TikTok because we were afraid that that platform had too much of our personal data and that was bad. So now here's some laws to say more intermediaries get to collect more personal data. None of this is not coherent, and the lack of coherence should be Exhibit A for maybe these aren't good ideas and there's going to be some constitutional and other harms that if we pursue them.
Not for nothing, I was talking to a lawyer at the Indiana AG's office a while back, and he was about the age verification for porn law, and he looked at me and he said, I don't know who they're going to get to take the job of sitting there and combing through these websites to figure out if 33+% of it is porn, but anyone who wants the job probably shouldn't have it.
Which is to invert part of what we've had in this conversation. I noticed that they've just outlawed, basically Pornhub just exited Nebraska. I'm from Nebraska, so that single way got my attention. And I wasn't sure how many states, and I'm gonna get the number wrong, but it has been interesting to see where they are, they're just like, we're out. Like, we can't meet the bar that you're putting in this state law, and so we're going to do our best. But everybody's VPNing around that.
If they were smart, they would start their own separate company and do VPN service.
Maybe they are. I was trying to decide how I was going to have the polite conversation when I go back for a football game. Hey, so are you still using Pornhub? Maybe not the way to go on that one. Todd, you brought up on our prep call the Report Act, because part of this is I don't want everyone to be left with the impression that we aren't interested in making a safe place for kids to be, but it's a matter of how you manage this, and then realizing when you're doing it that's constitutional or possibly not constitutional. So can you just give us a little bit of background on it, because it's something that was new to me and it's very interesting.
Sure, I think there are important things that we can all get behind that would meaningfully make the internet safer for young people. One of the challenges with the National Center for Missing and Exploited Children, NCMEC, is that they're historically under-resourced and are not able to fully investigate the reports that come into them. There's an additional problem, which is that when they have a case and they report it to a local jurisdiction, does that jurisdiction have the resources they need to fully investigate a potential crime? And it is a sad reality that too many of these end up not fully investigated due to a lack of resources. So the Report Act, which we supported at Chamber of Progress, sort of changes the aperture of who can report and allows for additional reporting mechanisms of potential suspected child sexual abuse material online. In addition, I think we need to go a step farther and look at legislation by Senator Wyden, Representative Fitzpatrick, and Representative Eshoo, and I hope I'm getting the name right. I believe it's the Investing in Child Safety Online Act. I might have mixed up some of the words, but that would then more fully fund law enforcement to allow them to make sure that they are investigating cases to the fullest extent necessary, so that it is a truly tragic scenario. It is a truly tragic situation when a case cannot be investigated, a case of potential child abuse cannot be investigated simply due to the lack of resources. If we have resources for anything, we should have resources to investigate cases like this. So I do think there are important and meaningful steps that Congress can and should take to protect children online in a way that would be entirely consistent with the Constitution and would avoid any of the issues that we've been discussing heretofore today.
I think for some of this, in how to regulate, you look at the problem and you have to think about, well, what do you want to have happen? And then you have to think about, well, what can make that happen? So one of the things is, if you want people to do something, how do you encourage it? And so regulations can do things that create carrots to encourage more of what you want. And, if it's a resource thing, the bills that are supplying resources sound like a good idea. But then the other thing you have to think about is you also have to make it possible. And one of the problems of, let me go back to that complaint about incoherence, is when you're just mad at something and you throw any sort of not particularly well-tailored law at it, you create consequences that may obstruct people being able to do what you wanted to do. So I think if we look at the Report Act, one of the things that caught my eye was it tried to actually undo some of the obstacles, because you wanted to be able to have reporting and accountability. If there was a problem, if somebody saw something, they could do something about it. And you created liability in a place where you weren't going to be able to have any good actor be able to do any good thing, because they were sitting in a situation where law was just going to hurt them if they tried. Well, that's not going to help anything. So that's the other consideration, whether we're talking Report Act or anything else. When you throw incoherent laws at significant problems, and those regulations have the laws of physics, there's some logical consequences to them, then you need other laws that help tune them better to roll it back, so that if you want somebody to do something, you have to make it legally possible for them to do it. If all of a sudden they're going to end up in a world of hurt legally, then you've done this wrong.
So going the other direction, leaving the States and thinking about what's been going on internationally, and right now we've had a lot of focus on Europe because they've been doing a lot of regulating over there. How are the different legal approaches to intermediary liability managed in other countries? And for those of you who are in the commercial market, are there just certain places where you've either seen a company vacate again because they're just we can't do this anymore? We can't meet threshold. And I realize the Digital Markets Act and the Digital Services Act are just starting to throw billion-dollar fines at companies. So I think more to come. Are we my biggest fear is we're starting to see the crumbling of the internet that we've had for the last 30 years. Am I the only one concerned up here about that? Okay. Thoughts on that?
Well, to the extent that there is some variously called splinter net, and I think it should give us all pause. I think there is a band of reasonable policy. There can be reasonable policy variances across borders. I don't think anyone disputes that. I think when you arrive at you look at whether it's in competition, where foreign government competition, U.S. competition authorities have sometimes looked to foreign competition authorities to sort of achieve overseas what they can't achieve here, to interfere with and stop mergers that happen not to be palatable for one reason or another, not actually violative of U.S. competition law, but let's just hope that the Competition Markets Authority can sort it out for us over here. It should trouble us when we see American competition policy regulators announcing that they're shoulder to shoulder with antitrust enforcers and competition policy regulators in Brussels or wherever else. I think, to your point, while we have not yet seen it, the trend lines in Europe are with the Digital Markets Act enforcements that are all seemingly just driven by anti-American tech animus and a desire to quote unquote rein in big tech in a way that is entirely contrary to the concept of innovation, entirely contrary to the concept of consumer welfare. We are seeing the consequences of some of these enforcement decisions that seem to be driven nothing by little other than the geography of where the domicile of the company and where it was originated, it does give me personally pause, and I think it should trouble a lot of us. I would sure love to see the next American administration really standing strong for American technology as one of the most innovative and vital sectors of the American economy and a global leader. I would sure love to see the next American administration standing up and saying, we have to say no to the splinternet. We have to tell, through diplomatic channels or what have you, stand up against things like digital services taxes and extraterritorial competition policy enforcements. I'm not sure that I entirely answered your question, but it is also something that worries me.
I realize there's a lot in there. I mean, we've seen with President Clinton, who really said hands off. We need to let it grow. And then Obama, definitely stepped up when needed on an international stage to say we need to protect the ability to utilize this tool. It's still growing. And now I'm worried that we're at a hopefully just a bump in the road. But I was also realizing that we're not the only one with courts, and they're not the only one that can levy fines around this. So I think there's going to be a lot to be seen in this space.
But I want to call some attention to a word that just went through in passing, which was extraterritoriality. Let me pronounce it better. Extraterritoriality. You know what I mean. Because that is worse than just the splinternet itself. It is one thing if every country is like, okay, you're going to Pornhub in Nebraska. If Nebraska is going to say you want to be here, here's our rules of the road, and then the companies can say we can't comply with that, they pull out. Now we're going to have splinternet if every state or every nation state can basically set its own rules of the road, and all of a sudden audiences themselves get splintered where okay, we don't like the rules of Nebraska, so we're not doing business in Nebraska or Spain or something like that. But it's something else entirely and much worse if the consequences of violating a law in one place where you can't just pull out of that place, where that place is going to have further reach, and being able to reach back in and have its own local judgment now be the operative judgment on everybody else, including places and parts of the world where that would not be what they would choose. That might not be what their policy choices are. That might not be what their constitutions would enable. And that's a much bigger problem. So all the laws that are we're going to look for your global turnover as something to fine, or from the previous discussion with Texas's law of no, if you don't like our Texas social media law, you can't pull out of Texas. All of that is designed for one jurisdiction to have a lot of veto power over every other jurisdiction. And that's beyond just splinternetting of everybody having their own rules of the road, because this is a really power play of jockeying that any one particular jurisdiction can set the rules of the road for the entire world. And I think from an American perspective, where we have a First Amendment, et cetera, that is not a good thing at all, and something that I think hopefully should be easier for American interests to understand about how important it is to push back.
I imagine deep somewhere in European bureaucrats' heads, they're hoping that this will have some kind of effect so that Europe can grow its tech sector, but they haven't successfully done that ever, so I'm not really sure what makes them think they're going to do it now. But it's precisely because of these types of laws that it hasn't happened, so if they think this is going to help, it's kind of backwards.
Kind of building off of that, just the companies that haven't released certain products or features in the EU because of the regulatory framework that they're facing, it's what impacts does that have not only to innovation broadly, but to the folks who are living in those countries and are not able to access those products and features that are available elsewhere. So how does that stunt their potential growth as well?
Yeah, we've seen that in the last couple weeks. Yeah, it's been interesting. All right, any last thoughts from the panel before I open to questions? Because I know there's going to be a lot of questions in this room. I know you were scribbling something.
Have a lot of thoughts.
Okay, just didn't know if you wanted to put the scribbles out loud because I was watching you scribble on your pad.
No. I think I got most of what I wanted.
Okay, all right, you got it off your chest, you're good, okay.
For now.
All right, anyone else before we open to questions? All right, we're going to open for questions, and Rick, we know you got one, so we're going to let you start.
I'm good.
Really?
Oh, that's disappointing.
Okay, all right. So questions from the audience, and then again, you can send things to ask at AEI, at AEI Tech on Twitter /X. Did we, okay, I was gonna say, did we exhaust the room?
We're just that good at
Right.
explaining things.
So to ping off a very recent discussion point we had here, you expressed opposition to European tech regulations. What do you think would be an appropriate reaction by the United States to European regulations that are hurting our corporations?
That is far too much in the realm of
I know,
politics
my
and
head goes
diplomacy for me.
My head goes very childish about chocolate and things that, yeah, like, you know.
Oh, that's
yeah.
way less childish than where my mind goes, so you're in shape.
Two thoughts. And they're not necessarily my founding strategy. Just consider me like, as the AI said, I'm a maverick. So I get to throw the maverick ideas. One of them is I just like it to even be on our diplomatic radar of something where we maybe wave the flag a little bit more and don't just roll over on these issues, because I think we're rolling over on them because we don't recognize them. So I think step one is to recognize that it is in our national interest to have a little bit more pride in our tech sector and in our constitutional underpinnings that get us our tech sector. So that would be thought one. Thought two, act defensively. We have something called the Speech Act, which is kind of interesting, which talks about how decisions from other courts in parts of the world that do not respect free speech the way we do are unenforceable in the United States. And I like it. It's good. And I'm wondering if we might need to expand that and have it a little bit more defensively, because there's going to be a lot of crap, and if that crap can't come to the United States, maybe that will start to deter some of the crap that's coming from abroad.
I think one of the problems with that is that it's easy. The Speech Act is a little bit of an easier haul because not many people have assets in other countries. These companies largely have assets, and in some cases, like in Turkey, they have to have like a physical person there who can be like hauled off to the gulag or whatever. So like it's harder to do the Speech Act because they don't have to come here to enforce it in U.S. courts. They can usually do it locally, which makes it, but if we can come up with a way to like defensively or even kind of issue some kind of retaliatory strike, if somebody does that, you know, I'm for it.
Yeah, a couple of things. I mean, yeah, the Speech Act is not a one-stop thing for the reasons that you said. I think I would like to see it because I see a lot of incursions around the edges, and I would actually like, I have argued in some litigation, like quashing foreign subpoenas, Speech Act being operable, and I won the argument, but the courts quite reasonably were like, I'm going to analogize to where it's going, but I don't think the statute gets you there. So I'd actually like to tighten the statute anyway. There would be value, but you're right, when you have boots on the ground. The other type of thing that I've considered is poison pill, where I've thought about this, although I can't fully flesh this idea out off the top of my head, but like with right to be forgotten, that basically that's fine, you do that, but there's going to be a consequence over here. And so there's other ways of dealing with that statutorily. But you're right. One of the problems for most of these companies is they've got boots in the ground in these other jurisdictions, and they need to be able to protect those boots.
But still, it could be useful messaging, if nothing else. But I think one of the other things you said is also quite right, is that we don't really acknowledge this as a problem. And I think that's because we have this like view of, oh, those crazy Europeans, like whatever, they're gonna do something, and they're not gonna see it how it affects us because we have different laws to protect us from such overreach. But again, like you just said, tell that to us when these other, the European countries are starting to levy fines against American companies that end up impacting A, the services we get, or B, in some kind of crazy world, they presumably can find a way to fine or punish a company for offering something in the US that if offered in Europe wouldn't be legal, even if nobody in Europe actually did it. I guarantee you, if anyone can do that, it's the Europeans.
Well, it'd be nice to also it'd be nice if we could push back against European regulation that we weren't trying to do to ourselves. I don't think, as long as we're busy trying to stab ourselves in the heart with the knife, I don't think we're seeing it as a problem that somebody else is trying to stab us with the knife. So put the knives down. We could start putting them down domestically, and also sort of recognize that when somebody else is coming at us with them, maybe that would be a problem.
So I am far from an expert on European law and policy and what would be an optimal policy regime on the other side of the Atlantic. What I can say is and to a certain extent, like if there was a question behind the question, what does American tech leadership look like internationally? And one thing I would really like to see, we're going to have a new administration one way or the other in January, whoever that might be. It's an opportunity to press reset and take a fresh look at some previous decisions we've made. I think this would be a great opportunity for the next administration to re-engage on digital trade negotiations, which were stalled out in about a year ago. So this would be an opportunity for us to work collaboratively with global peers on digital trade rules of the road and rules around things like data localization. So.
Yes, over. Kate, right here.
Thank you again. Thank you. My name's Ann Varum again. One thing in conversations like this that I always start to get a little confused about is the line between what is governmental required activity that may or may not be constitutional and private activity. And so is it not true that, for example, if Facebook decided to age gate, they could, as opposed to it being a state or federal statute or requirement. And so don't we always have to kind of differentiate what it is we're trying to protect against and, you know, just keep that conversational categorizations clear? Because in point of fact, you know, things like age gating or even topical are constantly being segregated, so to speak. People are being excluded out because they don't, you know, perhaps it's a platform for discussing football. So they don't want anybody on the platform starting to talk about ping pong. And they may block them if it gets to be an overwhelming ping pong conversation. So I'm just saying that it seems to me that these conversations always start to get a little rambling and a little opaque about what we can invoke constitutional rights against and what we can't, because they're private, they're not government action. Well, is that a valid observation? Thank you.
I think from my perspective, and perhaps we can all always do a better job of this, but from my perspective, this is entirely only about what the government can force companies to do. If Facebook decided it wanted to be for 18 or older tomorrow, it is well within its rights to do so. You are 100% correct about that. But there's also a question of when these laws are being passed and they don't directly mandate it, you have to really look at it to see whether the intended effect is coercing that result without actually saying you must do it, which poses a similar problem, which I think is really important for us to look at. You know, there's the whole, these bills say you don't have to verify ages, but you have to protect people under 18 from X, Y, and Z. Literally, the only way to do that is to verify age. So it is in effect compelled age verification, even if the statute disclaims and says, "Oh, we don't mean that." If it's impossible to do otherwise, then yes, you actually do mean that. But you're right that companies who decide of their own free will and accord to do something, they can do it. But we have to look to make sure that the government isn't kind of shoving them into it.
Meta does have products specifically for certain age brackets. And part of that is because in a lot of places in the globe, including the United States, people use like the WhatsApp product as just a regular dialogue with their family. And they will kind of forewarn parents when they say, look, we know that you've got somebody coming to an age bracket, things are going to open up in their world, because when they hit a certain number on there, then more things are available to them. And I don't want to guess that. I think it's 12. I think it's 12 going to 13. But so there are, those are all those things that you have to think through when you are a platform provider and people start to use the platform beyond, the original intent, and you have to keep building for those items along the way, which is part of the design conversation we've kind of hinted at here. Other questions? In the back over here.
Hi. So, in discussion with what Todd Boyle was saying with the Report Act, you talked a little bit about NCMEC and their understaffing. Do you think it would be a possibility to employ tech, some kind of tech filtering on their side, on NCMEC's side, without violating the Fourth Amendment?
Oh, I'm not. I see Ari reacting, so he may be.
That is a barrel of monkeys.
Better equipped to answer this.
I'm not sure I am, to be honest.
I'll also offer the caveat that I'm not an attorney, so I'm not the expert on the Fourth Amendment here. When you say filtering, I want to make sure I understand. You mean that the sort and filter the reports they're getting to identify the most meritorious? Do I understand the question correctly?
Yeah, something to work with like the hash value data and discriminate between which type of content is which type of content.
In other words, like most likely to be violative of the law. I don't know what their technical capacity is, to be honest. So I'm not able to answer that question, but perhaps others are.
I'm not sure if that in itself is actually as far a leap as I thought from the original question. It's like NCMEC, it is, funded by the government for, when it does searches, it is a state actor. But if they already have the hash data and it's just working with the data they have already been provided, I don't see a reason why they couldn't employ tools to help them sort them in terms of, investigate this first, this second. Nothing off the top of my head strikes me as particularly problematic. But I will also issue the caveat that I'm not a Fourth Amendment lawyer, and that has been a very contentious.
Yeah, there's some people who are very, very expert in the space, and I would defer mostly to them. But what's been controversial is demands for thou must use tools thusly on your own systems, and those tend to create things with the issues. In terms of other tools available for things on other people's systems, that may create its own issues, but it seems like that might be separate. But I don't think I've been hearing nearly as much of that. I've heard more with people like, great idea, let's do it this way, and they are terrible, terrible ideas, and listen to the experts pushing back on them.
I think that the question does kind of cut to the heart of the issue, which is, as I understand it at least, the Report Act was broadly bipartisan support. President Biden signed it into law recently. The only note of concern, I won't say dissension, but the only note of concern I think anyone voiced was, well, this may increase the volume of reports, and that will create a processing and may contribute to backlog. Again, I think the way that you address that is by fully funding NCMEC and law enforcement. So I think that while I can't speak to the specifics of the question you asked, I think the heart of the matter is that we need to fully fund law enforcement to do this critical work.
And technology can be used to make law enforcement more effective in ways that are not unconstitutional, and we should be looking for ways to do that.
Yeah, and for those who are not familiar with the Report Act, it supports law enforcement by requiring online platforms to retain content reported to the cyber tip line for a year, so it also has retention in there, as well as just helping get the cyber tip line known about, so it's something that people can use and enable for, and it has a whole section here on enabling modern technology. So it's definitely worth taking a look at. Don't mean to ignore this side of the room. Do we have any questions over here? All right, good.
Hi, so you all discussed the Invest in Child Safety Act, which my name's Krista Chavez and I'm from NetChoice, and we are very supportive of that bill. Do you guys have any other alternatives that you propose to lawmakers who want to address this solution, but acknowledge that age gates in various forms are problematic?
I can start, and I know this is something that NetChoice is also active in promoting amongst lawmakers as well, but the concept of digital citizenship, and it goes back to one of the talking points I shared earlier, is whether or not we want to age gate things on the internet, there's not this magic switch that suddenly says you are mature enough, or you are this is now developmentally appropriate for you to coincide with that. But again, teaching younger users how to responsibly and appropriately navigate the internet in a way that fits their needs, but also is teaching younger users to not, if they see cyberbullying, maybe don't engage in that activity and pile on, but talk to the appropriate adult in the room, or try to encourage your friends to not entrench in that type of behavior online, because it could have really detrimental consequences. But also using those tools, like one of the other items that we've promoted is some of the attorneys general initiatives to, I believe it was North Carolina Attorney General Josh Stein, who was promoting these tech agreements, which was just, essentially encouraging parents to have a candid conversation with their kids about what responsible use is, and responsible, or like setting time limits, and just having those really just baseline conversations about how to go about this.
At risk of being slightly less productive, what I like to tell people is one of the keys is to stop pretending like this is a new issue. It has always been a problem of figuring out how to keep kids away from the things that they shouldn't have. This is literally nothing new. It's existed since media existed, and probably since before that too. It's not new. And the fact of the matter is, no place is ever going to be 100% safe, and we should stop pretending like it will be, lest we end up in the same situation where kids are getting visited by Children and Family Services because they let their kid walk 2 blocks to the park by themselves. Like that is the same motivation that is driving this, and it's the same road we're heading down. And we've over time realized how crazy that in particular has become, to the point where there's an entire parenting style that is now backlash against that entire idea. So the more we try to push and shove the internet into a place that is ultimate safety, the less successful we'll be at actually making it safe.
Yeah. I mean, I think some general rules of regulation count. You have to carefully assess the problem you're trying to solve, and then carefully solve it. And the less well you do, even understanding what the problem is, the less well you'll solve it, and you'll just cause new ones. I might also join Ari in being a little bit more hardline on understanding that young people have First Amendment rights, and for very good reasons. And I think it's important that we recognize that. A lot of what's being proposed makes a lot more sense if you presume that they are just moldable clay that have no rights until they turn 18. And that's not the way the Constitution has ever been interpreted, or, as Kara was saying, really could be interpreted, because it's not like people turn 18 and all of a sudden, like, oh, now I have all my faculties to be a productive person because I've been so well educated leading up to this. There's reasons for student media concerns. There's reasons for, we were talking about students who are in unhealthy domestic situations. There's a lot of reasons, including some productive, where young people have some good ideas. And anyway, I would take a harder line on that, where it really needs to be, in a lot of these debates, we really need to have more of an appreciation of the First Amendment is a really cool thing, and it's really nice that we have all these rights. Because right now, I think overarching all these discussions is a sense of like that free speech is a problem, to get back to some of our earlier comments. And I think we really need to kind of put a different hat on and think about these things different. It is really awesome that we have a First Amendment, and it does a lot of really good things for us. And I think by and large, for both young people and adults, we need to consider what a benefit it bestows upon us and really start to appreciate that more. And then that also exudes into our own domestic policy and international relationships as well.
Well, Kathy just opened the door for me to revisit one of my scribblings. Okay. Just really briefly, like it dovetails that this is, one of the problems also is these laws also treat minors as a group as a monolith, a complete monolith. When you talk about having to serve the best interests of a minor, what exactly do you mean by that? Do you mean the best interests of each individual minor, which is literally impossible for a social media platform to do. And also, if you don't trust the platforms already, why are you going to make them your kid's psychologist? That doesn't make any sense. Or are you talking about the best interests of minors as a whole, which doesn't exist because every kid is different with different experiences, different maturity levels, different capacities. So when you end up creating a standard that's the best interest of all minors, whatever that means in any particular person's head, what you're doing is ensuring a suboptimal policy for every single child, which is nothing we should want.
I don't have a lot to add on that, but Chris, if there are any other legislative proposals that you're aware of, like we also strongly support the Invest in Child Safety Act, but I'm happy to look at others we could join you in support of as well.
Question over here.
Going back to old tech, there's an old expression, all the news that's fit to print. That's when a typesetter had to fit the news, all the typeset. So what does that really mean? Are they just printing? It's not judging the news, they're printing what they decide can fit in some way. So if you take the old New York Times expression of it's all the news that's fit to print, question what that actually means. But with First Amendment and free speech, if your rights come from your creator, the supposition then is you're supposed to be moral. So your rights then are you have defensive speech. That then gives you the right to say more if you have an issue. But
Part of the challenge is we all have our own first page of the newspaper now. We don't all see the same news.
I think we always have, because people are always selectively taking in media, you know.
Well, but he's saying like when you actually used to get a paper, Ari. Ari might know what that means.
I used to walk outside in February in Chicago in my shorts to get the newspaper.
Wow,
so
that is a level
that's my
of
version if I
dedication.
walk to school uphill both ways in the snow.
All right, last question from the audience. Anything from our, oh, we got one over here, great. That's it.
Very sorry to annoy everybody. I have no background in law, but as an observer or as a common sense go, right? You know, we all know, right? All intelligent people, there are normal, standard intelligent people. When we look at things, and you know, we pretty much have the same ideas and the thoughts and the worries and the admirations, you know, of what God has created or what, you know, as human beings as we are. So. How the legal system, like right now we are talking among ourselves, and of course, you know, this is most current and this is most important to us. But looking at the whole globe, you know, it looks like there's a lot of, just like whether God is there or not, you know, this sort of creator and the created and the, you know, owner and the owner, you know, the ones who own them. Lots of deeper thing that I will never be part of, and maybe not even eligible, you know, even if we want. So how are they dealing with these things? Do they just let it go on, or you know, what if they rewrite everything based on all these findings? You know, it's like I know some things we are not supposed to know, and it's dangerous. They say, right? So looking at all those things, how much the legal system, like let's see, this is the United States in the West, and then we have the Europe, and then the Asia, and all that. How I kind of assume that all the globally, these are all connected, and you know, maybe they're kind of talking at that level and then running the world. So how are we supposed to know these things and address certain things that shouldn't be going on and on? You know, it's so embarrassing. And yeah, so who's the most in charge, so to say? You know, I know they love to use the word power like that. What power, you know, what is this power? So who's most effective, and who's most, you know, does the Vatican or, you know, or among religion now the Muslims are the majority? So how, you know, or is there something that we don't need to worry, or just based on how we live and according to the need, we change the legal system or repair or, you know, make new laws now that we are into digital age and all that?
I'll take a stab.
Yeah. How can you educate? Like I'm here as a, you know, I'm an academician, I'm a high school teacher, and also like an ordinary citizen that, you know, I would like to know, and I kind of pretty much live quite well, not to be troubled by the law, but there are so many out there that how we can help them. You know, 50% off the, you know, like, you know, across the board or whatever. That are, you know, end up in the prison and that are being nagged and, you know, that are being all bothered every day and have to be so scared and worried. And so anyway, Okay, any answer? Please give some thoughts and make some noise or whatever. You guys among the legal world, you know?
Unfortunately, the law can't fix humanity's problems. That's kind of just another way of saying what I said before. Is we should stop expecting the law to fix all that ails human beings. Some things have to be dealt with as humans, as a society, as multiple societies. But trying to fix everything with the law is just a surefire way to fix nothing.
Yeah, and we have norms. Norms matter. Like, there doesn't have to be a law for anything. There's a lot of ways to impose consequences, not accepting behavior, we all have our own power that if somebody does something we don't like, we don't actually have to put up with it, and we don't necessarily need to go to the state and the government to make a law to deal with the person who's done something we don't like.
Well, I'm going to leave it on that note. A lot to think about. Thank you for that question. Please join me in thanking the panel today.